It is a lot. But in item number 20, my lord, is supplementary order. I filed, my lord, IAS, my lord. It's not on record, my lord. May it be called to record, my lord.
Why?
It is not come to the record.
What IA?
My lord,
IA for what?
IA for, my lord, it was the old pending case. I was filed for suspension of legal heir, condemnation, and all these things, my lord. Filed on last time, your lordship asked me to take some record. That's why.
Somebody died.
Yes.
When?
So that is district already made come to record, my lord.
When? When
Yeah,
did the person die?
My lord, they died long before, but I was informed on the December 23, my lord. At that time.
Bring the eye.
My lord?
Bring the eye. We'll take it up. 2007 matter.
Yes.
If I don't find good reasons, I'll dismiss the eye. Then we can proceed.
No, my lord, I was informed just on December.
What?
Last December.
So what? This court will
I
look into.
filed within time, my
We'll see. Call for the eye.
please, Lord. Lord, I beg to mention item number 12. That is for part 30 or item number 12.
What is it?
I thought it was part 30 for another.
Has it been written as part of?
Lord. It is not written, my lord. It says, my lord, the matter was hard, my lord. May I read
No. That can't be.
What?
The different thing I may not reach because I will take it serially.
What?
May not reach the different thing, but unless it is shown as part of that. Next.
May it please your lordship. Lordship, I beg to mention item number 25 of supply list, lordship. Lordship, kindly this matter may pass over for the day only, lordship. Lordship may take it up in the next week, lordship, any day as per lordship continues.
Why?
Lordship, senior counsel is out of station, lordship.
So what? Senior counsel out of station, hardly matter. We'll see. If it comes serially, I'll take it up. I'm not going to adjourn this whole matter. Yes, you may stay up 2021, 24, 25. Okay. Not other. Other matters don't mention it. It is only spoiling the time of the.
Once they are getting application is traffic in the CRP, lordship. So that is this.
It be in 5th. No, on 8th.
8th of April. May please your lordship. I beg to mention item, I beg to mention MSc Appeal 66 of 2022 for being ordered.
8.
2.
8.
My lord, I recommend for district or my lord of factor. Factor.
Why?
My lord, next is my lord, 2nd of April, my lord.
What is the matter?
My lord, what is my lord? It's my lord, financial company. And my lord, due to my lord, defaulter, my lord, the exponent, my lord, by the complaint, according to the default. And according to my lord, since my lord, the exponent is defaulter, my lord, the vehicle was my lord reported. And my lord, the concept, my lord, both my lord, 12 plus, my lord,
Okay.
apply. My lord, I'm praying for listing of this matter on 10th, my lord, civil revision petition.
Why?
My lord, this very small matter is long pending. It's hearing for long, my lord. It was listed for twice or thrice, but it's not reached, my lord. And
Hearing matter, no, no mention. Why declaration before this court? This court is not taking up writ petition. Next.
For listing one I MSc method on Monday, my lord, because the appellate property
Not Monday. We'll have it on 5th. MAC. Okay, 8.
Open. May please the Lord. I beg to mention for listing of MSC. For next.
Hmm?
For next week, Lord. MSC.
8. Not for hearing, huh? Is it for hearing?
Lord, I put it in admission, Lord. Admission. With regard to that order, Your Lordship. Yes.
Where is the order?
Lord, find page 62.
Hmm?
In order is the page. Page 62.
Page 62.
Yes.
Is it an application filed under order 907?
It appears so, Your Lord.
If it is an application under order 9, were you the defendant?
No, man. 10. He is the plaintiff.
Okay.
And my suit was for default.
Default. But that was not the date on which it was fixed
No, it was date fixed.
for hearing.
No, it was not fixed.
Where is that order?
Lordship could find page 27, I think. 28, man. 27 or 2.
This 12/2/2019.
Yes. Only one day, my lord. The court waited for till 1.
Otherwise, the suit is proceeding.
Yes.
Counterclaim is
Counterclaim is there. We are the tenant. He is the tenant under me. And my counterclaim is allowed.
What was the suit?
My lord, suit was for, my lord, regarding a premises, my lord, which was taken on lease by the plaintiff and defendant, my lord.
What is your suit for?
My lord, there is a school there, my lord, and the school was running. And
Where is your suit? Plain?
Lordship will find plain, my lord, page 14, man. He was not paying the rent, and we had taken steps against which he had initiated this. And there is an injunction order.
Has your written statement been accepted in respect to the counterclaim?
Yes, sir. I think it is reflected in the order. My lord,
Leho. This is an application under Article 57 of the Constitution challenging the order dated 30/9/2023 passed in case number 932 of the 2019 arising out of title suit number 209 of the 2018. By the said impugned order, the learned trial court, that is the court of the civil judge, senior division number 3, Kamrup Metro at Guwahati, had rejected the application filed by the petitioner for condonation of delay in preparing the application seeking restoration of the suit, which was dismissed for default by the order dated 12/2/2019. In fact, Mr. Because these type of orders, the court should not unnecessarily. There is a wrong notion of deciding what is an Order 9, Rule 7, they don't know something is wrong. That day I was getting a matter wherein Order 9, Rule 7 application was dismissed. And the other side out there has come before the court. The other side, the defendant or the plaintiff was saying that no, nothing is to be done. But the question arises, you need to file an application under Order 9, Rule 7 only for the purpose of putting the clock back. Otherwise, your participation in the suit cannot be stopped by the court.
Cannot.
And this very basic aspect has not been understood by the
You cannot be non-suited just because of
unnecessary. They don't appear because why the order of to proceed ex parte is to be done. Because in each and every order, there has to be a representation of the other side. What happens when the other side is not there? If you pass an order, it would be passing an order ex parte. So the order of proceeding ex parte is nothing but an administrative order for the purpose of proceeding with the. And this very aspect, these courts, they don't understand. This court have duly taken note of. The order dated 6/2/2019 passed in title suit number 209/2008.
18 years.
18. In the said suit, on that very day, the learned trial court granted the plaintiff an additional opportunity for filing the written statement on 12/2/2019. The suit 12/2/2019 for filing the written statement against the counterclaim filed by the defendant. The suit was not fixed for hearing. Next. However, on 12/2/2019, on the ground that the plaintiff neither filed a written statement to the counterclaim nor appeared on the said date, had dismissed the suit being title suit number 209/2018, but further proceeded with the counterclaim, thereby fixing 29/4/2019. Where is that order? Type copy, main order. 29/4/2019 for ex parte hearing in respect of the counterclaim. On an off date, an application was filed by the statement against the counterclaim filed by the defendant number 1. That is on 25/3/2019. The said counterclaim, the said written statement was kept on record and the matter was fixed on 29/4/2019 for hearing.
Then 1911. The 29/4/19 is 42. Is 42. Type copy does not tally. The type copies does not tally with the actual. Page 42, Lord. Page 42, I think, is the appropriate order after 29.
of 29/4/2000.
Parties are represented fixing 1719 for next
Huh?
page 42.
and written.
Type
Thereupon,
clerical mistake. Type copy. This 1911-2018 with 29/4.
Then again on page 29, we are lordship will get the subsequent order.
thereupon it revealed that an application was filed under Order 9, Rule 4, read with Section 151 for restoration of the suit, being title suit number 209/2018. On 28th of November 2019. Along with the said application, another miscellaneous application was filed under Section 5 of the Limitation Act, seeking condonation of the delay in preferring the application under Order 9, Rule 4. This application seeking condonation of delay was registered as Ms. case number 932/2019. But the impugn order dated 30/9/2023, on the basis of these applications being filed by the plaintiff, the suit being title suit number 209/2008 was kept in abeyance. The record further reveals that the impugn order was passed on 30/9/2023, whereby the Ms. case number 932/2019, by which the condonation of the delay was sought for filing the application under Order 9, Rule 4, was rejected on the grounds and reasons stated therein. It is under such circumstances that the instant application has been filed. This court has heard the learned counsel appearing on behalf of the petitioner, as well as the learned counsel appearing on behalf of the respondent. This court is shocked and surprised to take note of that on 6/2/2019, the learned trial court had fixed 12/2/2019 only for the purpose of filing of the written statement by the plaintiff to the counterclaim. If that be so, there was no reason on the part of the trial court to dismiss the suit on 12/2/2019, inasmuch as the suit was not fixed for hearing. It has been also brought to the attention of this court that in the meantime, the trial court have already permitted the filing of the written statement, accepted the written statement filed by the plaintiff into the counterclaim. Under such circumstances, This court further finds it very pertinent to observe that as in the instant case, the provision of Order 9, Rule 8 of the Code does not apply, taking into account that the suit was not fixed, not called for hearing. The question of filing any application seeking condonation of delay was not necessary. In fact, the dismissal of the suit by the order dated 12/2/2019 on the ground that the plaintiff was not represented is completely foreign to the provisions of the Code of Civil Procedure 1908. That too when the suit was not fixed for hearing, or as well as when the provisions of Order 9, Rule 2 and Order 9, Rule 3 did not apply. Consequently, this court not only sets aside the order dated, impugned order dated 38 to 39, 2020, 38 or 39?
39, 20.
39, 2023, passed in Ms. case number 932/2019, arising out of title suit number 209/2018, but also sets aside the order dated 12/2/2019, passed in title suit number 209/2018. This court further,
To the extent of the dismissal, because the other does.
remaining is nothing there.
The counterclaim part is there, Your Honor.
Counterclaim has already been there.
No,
It's fixed for issues, madam, on 28/5.
it is for fixed for issue.
Understood. I've set aside that. Sets aside the order dated 12/2/2019, insofar as the suit was dismissed for default. The title suit number 209/2018 is restored to the file of the court of the civil judge or court of the trial, the learned trial court. That is the court of the civil judge, senior division number 3, Kamrup Metro of Guwahati. The learned counsels appearing on behalf of the petitioner, on behalf of the parties, have apprised this court that the next date is fixed in before the trial court on
28/5, madam.
28/5, 2024.
issue.
24 for framing of issues.
Yes, sir.
Taking into account the above, this court directs the learned trial court to proceed with the suit along with the counterclaim as per the provisions of law.
My lord, the other some miscase was there. That was also, my lord, in view of the order. But to make any case 60. Other related miscase, my lord.
Huh?
Other related mistake case, my lord. One is for injunction and other two are also, my lord, for injunction. That may be restored. I have categorically prayer. Because in view of that order, my lord, other is also page 64.
Page
64. 64, 65, and
7.
one is 377, 2018, one is 607, 2018, and 608 of 2018. Because, my lord, mistake is number 92 of 2019 was I made prayer also.
This court further is of the opinion that in view of the fact that the order dated before parting with the record, this court further opines and observes that in view of the setting aside and quashing of the order dated 12/2/2019, the order dated 13/9/2023 passed in Ms. case number 377/2018, Ms. case number 607/2018, Ms. case number 608/2018 are all set aside. And the said Ms. cases are restored to the file of the learned trial court.
Page 64, another mistake case, 377.
What?
377 of 2008. Page 64.
I said there were three miscases. 377 of 2018, 607 of the 2000, 608 of 2018. What else do you require?
Another one, my lord, mistake case number 932 of 2009.
That is not necessary. Why do you want the restoration of a limitation application when this court have said that? Don't you hear what I am dictating?
Sorry.
We could impose a cost upon you. Unnecessary spoiling the time.
Obliged.
Yes.
May I please? Reported is the judgment and decree dated 3/11/2009, passed in title appeal number 48 of 2009, whereby the judgment and decree dated 20/3/2006 has been set aside by the appellate, the first appellate court.
Whether the certified copy of the sale deed is Exhibit 3 is admissible in evidence and the right title and interest can be decreed on the basis of a certified copy of such sale deed which have been marked as exhibit without any objection from the side of the defendant. Why not? You should have objected to it.
I am the plaintiff.
My lordship, actually, defendant, all defendant 6 1 to 6 is a actual honor of Switzerland, and pata number 71 and tag number 543 and 502. According to land measuring, 1 kotha 2 lesas and 1 kotha 12 lesas. Total land measuring 2 kothas 14 lesas. According to process, an official record of Jamabandi and Sita copy also tell this. Jamabandi copy here is available, my lord. Jamabandi copy. I want to give a affidavit.
Trial court,
Honorable court.
it is a concurrent finding.
No, my lord.
The finding of reversal.
Reversal.
Let's see the trial court judgment.
Actually, matter is very contradictory, my lord. It is also
My lord.
fact that Mrs. Fulton BP had sold to the appellant, appellant of 47/2010, Safia Khatun, a plot of land measuring 2 bigha and 2 lesas, covered by tag number 514,
Madam,
515, 516.
Madam, wait.
Yes, my lord.
Simple question is whether the certified copy of a sale deed
Yes, my lord.
was admissible in view of the same not being objected to at the time of tendering of the sale deed.
Yes, my lordship. So I want to give a affidavit. I produced a affidavit regarding all this evidence into anything, all evidence and all.
All the record is here. Why do I need the evidence? Don't make all these submissions out
no.
there.
Two
It is
times,
very
two times,
simple.
my lordship.
Madam, if you don't have to say, don't say. But don't make all these type of submissions before this court. You are live, you are there in live streaming. People may laugh. What is wrong in the High Court? The question is very simple. You are required to object if it is a certified copy. Sale deed having not been produced. You did not object. If you did not object within the judgment of 2003 7 SCC 350, 350 or 732, 732 would apply. At the end there, the answer is very clear. Let's see the trial court judgment.
Two times, the honorable court has
Plaintiff,
given
who is the
title.
plaintiff?
Given
Plaintiff
title
has filed a
to
suit for
defendant, my
declaration of
lord.
right title and interest for possession, partition along with consequent security. Where is the claim?
My lord, the translated part starts from my lord,
Actually,
page 11, my lord. May I submit?
Huh?
Recently, I have been engaged in this case, my lord. After going to the record, my lord, to assist this honorable court, I have prepared the additional substantial question of law. If your lordship may permit me,
Why?
my lord, the prayer made by the plaintiff was the three parts, my lord.
Let us see the plaint. Where is it?
My lord. Starts from page 11, my lord.
Where is the plaintiff? My goodness. Plaintiff, four plaintiff, five plaintiff. Wife of so and so Samsul Ali. So Samsul Ali is the main person.
Samsul Ali is the
The defendants are so many. Who are the defendants?
my lord.
defendant
1 to 6 is the principal defendant, my lord.
Other the
And,
performer?
other performer, my lord, and 96, my lord. Other did not contest the suit, my lord.
7 to 96 did not contest the suit.
7 to 95 did not contest, my lord. 96
Contested.
contested, my lord.
Let's see the suit
There-
for amicable partition, decree for possession and permanent return. The schedule
my
for
lordship.
le- Exhibit A is the certified copy of the 67 deed.
Yes.
And why it is said that Mark A is the certified copy of the registered deed?
My lord,
Why not Exhibit A? Exhibit 1 is the certified copy of the one, Exhibit 2 is there, Exhibit 3, Exhibit is the certified copy of the deed. And what is this Mark A? Mark A is the certified copy of the registered deed number so
Registered
and
deed
so
number.
dated demand executed by Fuljon
Okay.
Bibi. Fuljon Bibi is who?
Sultan Bibi, defendant number 96, my lord. She is the daughter of the original
Amar Ali.
Amar Ali.
Hamid Ali.
Amir Ali.
Amir Ali had two daughters.
No, my lord.
No.
One daughter, one
daughter,
wife.
Wife, after death of Amir Ali, married with Samsul Ali. Samsul Haq.
Wife.
Wife married.
Wife.
Yeah, wife married with Samsul Haq. Then, my lord, after death of Amir Ali's wife, my lord, Fuljan Bibi, my lord. Fuljan Bibi, after death of Fuljan Bibi, Samsul Haq married present
Sultan
plaintiff.
Bibi, no, not it, my God.
No.
That's it.
You are
Sultan
making
Bibi
a
alive.
mistake.
Gulzan Bibi.
Guljan Bibi.
96, defend number 96 is who?
Defendant number 96 is the daughter of Amir Ali.
Actual landlord.
No. Amir Ali had two persons. One is Fuljon Bibi
One is Gulzan.
and one is Gulzon.
Gulzan.
Gulzan
Gulzan
or
is the wife.
Huh?
Guljan Bibi, daughter, my lord.
Fuljon Bibi is the daughter,
Daughter and Guljan Bibi,
is the wife.
Wife.
Okay, Gulzon Bibi is the wife, Fuljon Bibi is the daughter.
when
Now,
Hamid Ali died.
Fuljon Bibi married Samsul Ali.
Gulzan Bibi married Samsul Ali.
And the
Wife.
wife of Hamar Ali married
After
Samsul
died
Ali.
Hamid Ali, after died of her husband, she has taken away one man from Tezpur, possibly, and declared as married him.
Okay,
Actually,
so
the land is-
Gulzon
land
Bibi
Ah.
married Samsul Ali.
Samsul.
Okay, from thereupon Gulzon Bibi died.
Gulzan Bibi died. Then Samsul Haq, my lord.
Samsul Ali.
Samsul Ali married, my lord, Safia Khatun and
Safia Khatun.
Safia Khatun, my lord.
Now, Safia Khatun was the first wife of Samsul Ali.
Samsul Ali, but
And then he he divorced her. Then he married Gulzon Bibi and then remarried this Safia Khatun.
Safia Khatun.
That is it.
That is-
Now, that is one aspect. Now, Gulzon Bibi executed a deed of sale
Deed of-
in favor of
This, my lord, Safia Khatun, plaintiff number 1.
Safia Khatun.
Right.
That is of the deed of 1967.
67.
Now, tell me, if you see page number 62,
My lord.
paragraph 8, plaintiff side has examined as many as 6 witnesses, including the plaintiff number 1 and exhibited, relied upon documents in support of the claim, whereas the defendants have examined as many as 2 witnesses exhibiting exhibit 4, go. Now you see, Mark A is the certified copy of the deed number, I think it should be 67,
67.
executed by Fuljon Bibi in favor of Safia Khatun. Exhibit 1 is the certified copy of the order dated 11/12/99 in case number so and so passed by the executive magistrate. Exhibit 2 is the certified copy of the Jamabandi of so and so. Exhibit 3 is the certified copy of the order, circle officer. Exhibit 5 is the certified copy of the registered sale deed of 63 executed by in favor of Gulzon Bibi. Mark B is the certified copy of the registered sale deed dated so and so by Gulzon Bibi in favor of Samsul Haq. So Gulzon Bibi sold two
land.
executed 2 lands,
Two land.
2 sale deeds. One was in favor of the plaintiff number 1.
Actually, my lord, he said,
Two
He said-
salesmen. Two
Huh?
my lord,
plots.
the schedule 4 schedule now consists of two plots of land, my lord. One has been transferred by the registered sale deed. Second part has been transferred to a unregistered sale deed.
Unregistered sale has no value.
But-
We are not going to go into that. So under such circumstances, this land, Kulsan Bibi, that is the daughter,
Of Amira.
sold in the year 1967
67.
in favor of Safia Khatun.
Okay, plenty.
Now, what is the second sale deed in favor of Gulzan Bibi? That is 63, that is the unregistered one.
No, my lord.
That's also a registered document.
That is not sale deed, my lord. That is transfer deed, my
What is that transfer deed?
lord. That transfer deed, my lord. Kuljan Bibi has transferred her proportion of land, my lord, inherited by her in name of her mother.
Her rights.
All right.
But that was done prior to
Prior
67.
60.
Now, if this deed comes in, did Kulzan Bibi have the right to transfer?
My lord, yes, my lord. Why? Because on the date of my Kuljan Bibi, Samsul Ali and Kuljan Bibi had no issue, my lord. So, as per Muhammadan law of inheritance, my lord, since she is the only daughter, my lord, daughter left, my lord, of Kuljan Bibi, my lord. So, she will inherit half part of Kuljan.
And remaining?
Remaining half will go to her husband, Abdullah. Hanifi law of Muhammad.
So the 67 deed had no value.
67 did it came in existence after my lord, date of Guljan Bibi.
Excel fact, my lordship. Excel fact, my lordship, for which part had sold by Kuldan Bibi to Sophia Khatun. In this area, 543 and 502 Kesapata number 71 was not included, my lord. That tag number was 514, 515, 516, 526 under Pata number 71, my lord. Dispute is here, my lord. Sultan Bibi has sold 543 and 502 defendant number 126, my lord.
When was the suit filed?
My lord, there are two suits, my lord. One was earlier withdrawn with liberty to file afresh, my lord. Then, my lord,
No, then does not enhance the limitation.
yes, my lord.
Yes.
The suit was filed, my lord, on 2004, my lord. Day 2004, my lord.
Sale deed is of 1992.
To 1980.
You knew about that in the proceedings under 1992?
Yes.
Then why, how you are saying that you have not you have not challenged the sale deed till then? How can the sale deed be set aside?
My lord, it is regard my humble submission to be there, my lord. I am entitled to the benefit under section 14 of the Limited Act, my lord.
For what?
My lord, wrong forum we have approached, my lord. Till 1999, my lord, we are in the court of executive magistrate.
No. That cannot be the wrong forum. You cannot challenge a sale deed before them and get an limitation. That cannot be done. And after here, the trial court holds that after the death of Gulzan Bibi, the entire right transferred to Samsul Ali. How is it possible?
My lord, not entire right, my
No, it has been stated out here. Kindly see. Page 70. Page 69, last one. They have admitted in paragraph number 11 of the written statement that Gulzan Bibi relinquished her right, title and interest in respect to her mother Gulzan by registered sale deed dated Toronto. And Samsul Ali, husband of the plaintiff number 1, married Gulzan Bibi. And after the death of Gulzan Bibi, Samsul Ali again married the plaintiff number 1. Gulzan Bibi admitted in her written statement, in view of the fact above, Samsul inherited the property left by Gulzan Bibi, and on the death of Samsul Ali, the plaintiff acquired the right. But what about the share to the mother, daughter? No daughter. Daughter doesn't get anything.
My lord,
The daughter remains the daughter.
daughter remains the daughter.
The daughter will get the share.
Daughter will get the
And when the husband and only the daughter is alive,
Hello.
then in that case, the husband will be the residuary.
half, half, my-
Half.
half, 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 half. Half portion is husband's, my lord. And we have to see, my lord.
Now tell me, in 1992,
My lord.
the sale deed, did she sell the entire land?
No.
How much?
One katha, my lord,
Defend number 1 to 6 was sold. How much land?
my lord, one katha, yes. One katha, two lesser.
So you are selling, that is which schedule?
Schedule kha, my lord.
Kho was
Kho.
sold.
Schedule
Now,
kha
if
part
you
one.
cannot challenge this, you cannot challenge the sale deed because you knew about it in 1992. Part by limitation, the court could not have exercised that. So there it goes.
My lord, prior to that, my lord,
Let's see the first appellate court, what is here done. In fact, that question of law which you are framing has no relevance. I suppose.
it's my lord, I have
Actually,
it is
actually, in this suit, my lord,
Wait,
appellant
let
is,
me read this.
not connected in this suit land.
Let
Anyway,
us
my lord.
read this.
my lord, start from page 92, my lord. Appellate court, sir.
Now plaintiff number 1 married PW3.
Later on.
Whatever may be later on.
No, not married, my not married.
It is given at page 65. She has admitted that Afzal Ali was her husband. She was married to Afzal Ali, obtaining a divorce decree between plaintiff and Afzal Ali. Plaintiff number 1 cannot be the heir of late Shamsul Ali. Hence, this suit without a prayer of the plaintiff to declare plaintiff number 1 as the heir of so and so. The pleading of the heir to inherit the property of the heir is not maintainable. Hence, this suit without the two prayer to declare Shamsul Ali and so is not maintainable. Again, as per the pleading of the plaintiff, defendant number 96 has no any property in the suit patta. The name of Pulzar appears in the Jamabandi and the suit patta is so and so. Appearance of the name of so and so in the Jamabandi presumes that she has land in the state. Hence, in this suit, as per the pleadings of the plaintiff, if the defendant number 96 has no land in the suit patta, her name of mutation is hence in the suit without a prayer of the plaintiff to struck off the name of the defendant from the Jamabandi demanded. A partition must not be granted if included in an application following the note of different investigation. On the other hand, all co-pattadas are joined as dependent. They have not raised any objection to the so-called title may be declared under the plaintiff. In this regard, evidence of plaintiff number 1 and Khabar Ali are appreciated.
That marriage between it is the submission of the defendant, by he retains it.
So the limitation point went against you in the first appellate court.
Yes.
No, the issue
Article
number 2
65.
was
Yeah.
on your favor.
Not only limitation portion, my lord. although defendant side did not contest the, with regard to the schedule co, my lord, that was also decreed against my lord.
No, no. You did not exhibit that document.
I did not.
You did not.
Did
In
not.
fact, they also did not. They only brought it. That is why I asked you why it is said as Mark A. Mark A is proved because at the time of cross-examination it was brought. So this is done in terms with the proviso to section order 13 rule 2 that this would not stop you from bringing that. But that does not become an exhibit. That document is not exhibited. Then how does this question of law arise? First of all, your suit was barred by limitation.
But
And without setting aside that, you can't get a relief. And you have not challenged that or filed a cross objection as regards the issue number 1.
no problem.
Then it was held that the suit was not maintainable. Surprisingly, without the suit being maintainable, this has been done. And why were you asking for partition? I didn't understand that aspect.
My lord, my duty is so I maybe thank my lord. Because of the fact, my lord, perhaps it would have fact that the period of limitation, right? So that the suit is filed within the period of limitation, my lord, 12 years. Perhaps this has been done.
Your partition will only come after you show your title.
My lord.
But where is your title?
Title is, my lord, register sale deed. I have got the title. My lord.
Which one?
My lord, the 67 sale deed. 67 sale deed.
But did you bring the 67 sale deed? Exhibited it?
No, not
Then
but that is admitted. That is admitted, not disputed. And in fact, my lord, 67 sale deed is with regard to schedule go, my lord.
now what is the defendant number 1 to 6 disturbing you? Defendant number 1 to 6 is only on that sale deed.
Schedule go.
Understood?
Yes.
And that schedule core could not have been touched by you because of limitation. Then you don't have all other things doesn't remain.
Only fact that, my lord, as per Article 65, my lord, the period of limitation, 12 years. Runs from
How are you bringing 65? I don't understand why you are bringing 65.
position become adverse, my lord.
Are you claiming adverse position?
I am not claiming
Who is claiming adverse position?
the party. That opposite party.
They are claiming adverse
They
position
have
in
to
respect of some other land or exhibit core.
exhibit for schedule for, my lord.
So They purchased in the year to 1992
1992.
on its own right. Then obviously, wouldn't it be constitute an adverse possession by divorce? The sale deed being right or wrong because you have filed the suit in 2004. Irrespective, we need not go into that. 65 does not come into. On the ground of 54 only we can deal your matter and finish it up.
Further, my lord, the learned first appellate court, what learned first appellate court has done, my lord. Although the defendant side never contested in respect of civil law, my lord.
Defend number 126 contested.
126 never contested in respect of civil law land, my lord. Neither the defendant number 96, my lord. That civil law land has been decreed against me, my lord. Reversed.
Schedule Gaul land belongs to whom?
Me, my lord.
How?
Shall lead
Of
67 shall lead, my lord. 67 shall lead. That has been admitted that the civil law has been sold to me, my lord. But the defendant side, my lord.
let us see your relief. What did you ask for? Schedule go is 1 biga 2 kotha 1 biga 2 lecture comprised of dark number 3 to 6,
Tag number
5 to 6
Different.
of schedule 4. Schedule 4 is
73 biga 3 katha 11 letters.
what?
Schedule co is consists of 73 biga.
Schedule 4,
Schedule co, my lord. Schedule
73 bighas.
yes, my lord.
Okay. And
Schedule
schedule 4 is 1 katha 2 lectures comprised of 5 dark number 543 of schedule 4. And schedule go and another one, plot of land measuring 1 katha 12 lectures.
That is unregistered sale deed, my lord. I have answered to sale deed. Executed by
No, and the sale deed made in 1992 in her favor
number 1, my lord. Schedule co, plot number 1, my lord.
is in her name.
Yes.
Or defend number 1 to 6.
One to
on the six.
And as regards number 2,
that is unregistered.
so there also no right to the who transferred this?
96, defendant number 96, my lord. To unregistered sale deed.
Unregistered sale deed was it exhibited? No.
No.
So how can the court give you that? Now number 3 is schedule go. Schedule go. Let us see how do you explain schedule go. It's a very difficult thing to explain. I mean, paragraph the schedule go schedule belongs to the plaintiff number 1 as purchasing the land of possession therein in the state land measuring 2 biga 2 cut letter. What is this 2 biga 2 letter?
That's-
Here you mention as 1 biga 1 lets 2 letter
Biga 2 letter, my lord, was transferred.
was purchased by the plaintiff number 1 from the defendant number 96 on so and so by registered citizen Sultan BP or has no other right to the land to the defendant number 1 to 6. Sultan BP Sultan has has to take the if the no, you yourself says that they have purchased this schedule Golan in your plane, paragraph 2. Let's see the defendant.
My lord, this was wrongly translated. My
Huh?
this paragraph 2 is not properly translated. My
I don't know. I can't help it.
it's 28, my lord, the particular part. নিম্ন গ তফসিল বর্ণিত জমি 1 নম্বর বাড়ির নিজ বিপরীত সত্ত্ব দখল জমি হয়। উক্ত জমি সহ মোট 2 বিঘা 2 লেসা জমি 1 নম্বর বাড়ি 4 নম্বর
So at paragraph 7, they say that they have nothing to say about schedule go land.
the entire decree, judgment and decree passed by the trial court was interfered by.
And what does Kulzon Bibi say about schedule go land in her written state?
He admitted, my lord.
Where?
My lord.
Where is the written state?
Yes, my lord. Page 39, my lord.
This is the defend number 1. 1 to 6.
And then number 96 is
But that document was not exhibited.
that document was on page 51, my lord.
So who has written this? This is by defend number 1 to 6.
No, my lord. Page 51 is defendant number 96, my lord.
No, this is page 39.
Page 39 is defendant number 1 to 6, my lord.
Ah.
And page 51 is the WS of defendant number 96, my lord. Second paragraph, my lord. The register sale deed was admitted.
How much property did she inherit?
Uh,
There's 73 bighas. Amar Ali was the
No, no.
Patsu
Amar
Patta.
Ali was the original owner of 6 bighas.
So therefore, she did not give up the entire land. You see, she says at paragraph number 10, that subsequently she had relinquished the land measuring 3 bighas, 1 katha, 2 acre of dark numbers so and so in favor of her mother Iman, and she had sold away another plot of land measuring 2 bighas, 2 katha of dark numbers so and so to the defendant number 1. See, 2 bighas, 2 lectures of dark numbers so and so in favor of Iman. He remained as the absolute owner and possessor of the other landed properties of the deceased father. The plaintiffs have never acquired title over the other lands than the land relinquished and the land sold to the plaintiff number 1.
This is the part of the settlement. Later on, my lord, out of this bigha, 2 katha, my lord, 1 bigha, 1 katha has been sold.
Has sold to the plaintiff number 1 a plot of land measuring 2 bighas so and so. Yes, what additional substantial question of law?
My lord, only it's first.
Huh?
Since the defendant side did not contest with respect of still ball and my lord, whether the prospective court was justified think the reversing the judgment and decree passed by the
In so far as schedule go.
ball end. And my lord,
We then do one thing. We frame that question. He has no objection to that. We'll frame it and decree the suit only in respect of schedule go, nothing more than that.
Yes, my lord.
Without disturbing her, schedule,
Yes, my
you are
lord.
in schedule 4.
Civil
Yours is 4. We are
Schedule
only
law.
limited
50.
to
Schedule law, only
543 and 502, for example. Bearing that. It is no any connected in dispute, my lord.
I think
My
that
lord.
is the best.
Unnecessary harassment.
Because otherwise this court has to remand it.
Oh, your respect may remand it back, my lord.
Why?
Because my lord, kindly see, what the defendant has stated in her WS, my lord, is the inherited from her father, my lord. She could not, as per moment, she could not inherit the entire property, my lord.
Or we can do one thing very well. The question of law which have been framed is not a substantial question of law involved, and easily I dismiss the appeal, and then you go to Supreme Court and get a decree from there. Unnecessary. You are getting only schedule go, that is enough.
Yes.
Nothing for the beyond.
Yes.
Isn't it?
Yes, my
Nothing more than that. Don't disturb the defend number 1 to 6. And what about the partition? She has purchased which one?
My lord, schedule 4, part 1, my lord.
You have purchased which land? How much? Where is your sale? And who is appearing for Fulton BB?
My lord, dispatch service of she did not appear.
But she has admitted in her written statement about schedule goal.
Yes.
Let me come back. I'll dictate the judgment in your presence. Present appeal. Has been filed under section 100 of the Code of Civil Procedure, 1908, challenging the judgment and decree dated 3/11/2009, passed in title appeal number 48 of the 06 by the Court of the Civil Judge number 1, Kamrup, Metro at Guwahati, by the Kamrup at Guwahati, Kamrup, Guwahati, as it then existed. Now, the Court of the Civil Judge number 1, Kamrup Metro at Guwahati. This court, by an order dated 12/5/2020, admitted the instant appeal by formulating the following substantial question of law. For deciding as to whether the said substantial question of law arises, is involved in the instant appeal, this court finds it relevant to take note of the facts which led to the filing of the instant appeal. One, Amir Ali, since deceased, was the father of the defendant number 96, that is Fulton BB. and his wife was one Guljan Bibi. He left behind various properties at the time of his death. Subsequent to the death of late Hamir Ali, the defendant number 96 relinquished land measuring 3 bighas, 1 lecha, 2 quarts in dark number 534, 536, 522 of KP Pata number 71 in favor of her mother, Gulzan Bibi, and she sold away a plot of land measuring 2 bighas, 2 lechas of dark number 514, 515, 516, and 526 of KP Pata number 71 to the plaintiff number 1. This sale, which was made in favor of the plaintiff number 1, was done by a registered deed of sale bearing deed number 3766/67. Thereupon, the it is also relevant to take note of that prior to that after the death of late Hamir Ali, his wife Gulzan Bibi married one Samsul Ali, who is the predecessor in interest of the plaintiffs. Thereafter, Gulzan Bibi expired, and the said Samsul Ali married the plaintiff number 1, and the plaintiff numbers 2 to 5 are the sons and daughters out of the said wedlock. The plaintiffs in their claim that are by the registered sale deed bearing deed number
44.
Hmm?
This is the sale deed number 944 of 19.
No, no. When did you buy? Did you buy schedule colon? Colon. How did you buy schedule colon?
Defendant 126 brought the schedule colon, my lord. By sale deed number,
Did you buy the schedule colon?
No.
You had no right. There was a deed of 1967 is that deed. Only schedule go,
schedule go,
not schedule co.
not schedule.
So there was no purchase for any other document.
No.
It is the case of the plaintiff that the defendant number 96 by the deed of sale bearing deed number what is the deed number? By the deed number 944/92 dated 7/8/1992 transferred a plot of land measuring 1 katha 2 lecher comprised in dark number 543 in favor of the defendant numbers 1 to 6. As per the plaintiff, the defendant number 96 could not have transferred the said deed of said land in favor of the defendant numbers 1 to 6 on the ground that the defendant number 96 did not have a saleable right. It is also seen from the plain that out of the 2 bighas 2 lechas of land which was sold in favor of the plaintiff number 1 by the defendant number 96, an area, a plot of land measuring 1 bigha was sold by the plaintiff number 1 in favor of 1 Golbanu Bibi. The remaining plot of land measuring 1 bigha 2 katha 14 lechas. Isn't that?
Yes, my lord. 1 bigha, 2 lecher.
1 bigha 2 lechas. With the plaintiff number 1 have been more specifically described in Schedule Go. This court also finds it very pertinent to take note of that a proceedings under 145 of the CRPC was initiated by the plaintiff number 1 against the defendant number 1 to 6, being case number 266 bracket M/92 on the ground that the defendant number 1 to 6 had no authority on the ground that the state defendant numbers 1 to 6 wanted to dispose of the plaintiff from the said land, more specifically described in Schedule Q to the claim. It is also relevant herein to mention that the schedule core to the plain comprises of two plots of land. The first plot of land measures 1 katha, 2 lectures comprised under dark number 543 with definite boundary. And the second plot of land measures 1 katha, 12 lectures in dark number 502 with definite boundaries. During the said proceeding, under section 145, which was initiated, the defendant number 1 to 6 filed a written statement and stating therein that they had purchased the plot of land measuring 1 katha How much land did you purchase?
My lord, that 1 katha land, sorry, yes, 1 katha, 2 lecture.
That they had purchased 1 katha 2 lectures of land. By a registered deed of sale bearing deed number 944/92, which was covered by dark number 543 of KP Pata number 71 of village Jalimura under Niz Motortola Moza.
Needs matter.
And since the date of their purchase, they have been enjoying possession over the said land. In addition to that, it was also brought to the notice that another plot of land measuring 1 katha 12 lecture covered by dark number 502 of KP Pata number 71 was transferred by the defendant number 96 by a Kacha sale deed dated 28/9/1992, and the defendants have been possessing the said land till date undisputed. It was also categorically opposed. It is under such circumstances the plaintiffs filed a suit in the year 2004 seeking a decree for partition semicolon Khas possession of the land described in Schedule Kho and Schedule Go semicolon. The sale deed bearing deed number 944/92 dated 7/8/92 be declared void and the mutation of the defendant number 1 to 6 on the basis of the sale deed be corrected in the revenue records by the revenue authority. Pursuant to the filing of the said suit, the defendant numbers 1 to 6 filed their written statement stating inter alia that late Hamir Ali was the original owner and patadar of various plots of land measuring 6 bighas, 1 katha, 2 puas, covered by dark numbers 543, 502, 526, 514, 515, 516, 536, 534, and 522 of KP Pata number 71 of village Zalimura under Niz Modortula, Moza. After the death of late Hamir Ali, late Kuzal, the defendant number 96 inherited the entire property and relinquished a plot of land measuring 3 bighas, 1 lecha, 2 puas, covered by dark number 534, 536, 522 of KP Pata number 71 in favor of her mother, late Gulzan Bibi. It was mentioned that late Gulzan Bibi, immediately after the death of her husband, late Hamir Ali, married one Samsul Ali. And after the death of Gulzin Bibi, the husband of the plaintiff, late Samsul Ali, has sold away the entire land measuring 3 bighas, 1 lecha, and 2 puas to different purchasers, and the said purchasers have been possessing the said land till date. It was further mentioned that the defendant number 96 sold away another plot of land measuring 2 bighas, 2 lechas, covered by dark number 526, 514, 515, and 516 of Pata number 71 to the plaintiff number 1 by a registered sale deed bearing deed number 3766/1967. In addition to that, the defendant number 96 also sold the land measuring 1 katha, 2 lechas, bearing deed number 944/92, covered by dark number 543 of KP Pata number 71 of village Zalimura under Niz Modatola Moza to the defendant number 1 to 6. And they have been in possession of the said land since their date of possession, from the date of purchase. In addition to that, the defendant number 1 to 6 were also sold 1 katha, 12 lechas of land covered by dark number 502 of KP Pata number 71 by Kacha sale deed dated 28/9/1992 by the defendant number 96. And the said defendant have been possessing the said land till date undisputedly. It was specifically stated in the written statement that the plaintiffs at no point of time had right, title, and interest over the land under dark number 543 and 502. Full stop. The defendant number 96 also filed a written statement categorically stating that she had sold a plot of land measuring 1 katha 12 lesser, 2 lessers, na?
What kind of place?
2 lessers in favor of the defendant number 90, defendant numbers 1 to 6 by the registered deed of sale bearing deed number 944/92 dated 7/8/92. It was categorically mentioned that the plaintiffs are nowhere connected with the scheduled core land. In addition to that, the defendant number 96 had also mentioned that she had only relinquished the land measuring 3 bighas, 1 lesser, 2 koas of dark number 534, 536, and 522 of KP Patra number 71 in favor of her mother, Guljan Bibi. And she had sold away another plot of land measuring 2 bighas, 2 lechas of dark number 514, 515, 516, 526 of KP Patra number 71 to the defendant number, to the plaintiff number 1. In addition to that, it was also mentioned that after the marriage of late Guljan Bibi with late Samsur Ali and the subsequent death of late Guljan Bibi, Samsul Ali sold away the entire land of dark number 534, 536, and 522, which was relinquished in favor of late Guljan Bibi by the defendant number 96 to 3 different persons. And the said 3 different persons have acquired right, title, and interest in respect to the said land. It was further mentioned further to that, it is also seen that it is the categorical stand of the defendant number 96 that the plaintiffs had no right, title, or interest in respect of dark number 543 and 502. On the basis of the said, it is relevant to mention that the other defendants who were a performer in the suit did not participate in the trial and did not also submit their written statement. On the basis of the said issue, pleading, as many as 6 issues were framed, which included the issue number 3, that is whether the suit was barred by limitation, semicolon. Issue number 4, whether the plaintiffs have right, title, and interest over the land described in Schedule 4 and Go of the plain. And issue number 5, as to whether the sale deed number 944/92 was liable to be cancelled. It is, however, very interesting to take note of that the issue number 1 is as regards the maintenance of the suit in its present form. Full stop. The learned trial court, by the judgment and decree dated 23/2005, decreed the suit in favor of the plaintiff. However, had decreed the suit in favor of the plaintiff, in spite of holding that the issue number 1, which pertained to as to whether the suit was maintainable, in spite of holding that the suit was not maintainable, in issue while deciding the issue number 1. The issue pertaining to limitation was decided in favor of the plaintiff, although even after taking into account that the said deed of sale dated 7/8/1992 was challenged almost after 12 years by filing the suit. The issue number 4, as to whether the plaintiffs have right title and interest over the Schedule Q and Schedule Go plot of land. The said issue was decided in favor of the plaintiff, even without taking plaintiff. It is, however, relevant to take note of that the learned trial court did not take into account as to how the plaintiffs had right title and interest in respect of Schedule Q land. The issue number 5, as to whether the sale deed number 944/1992 was liable to be cancelled, was also decided in favor of the plaintiff's holding that the defendant number 96 did not have a saleable right. Being agreed by the said judgment and decree passed by the learned first appellate by the learned trial court dated 23/2005.
2006.
The order says 2005 or 23/2006. Judgment was legislated 2005. 2006, 23/2000. An appeal was prepared by the learned by the appellant by the defendant numbers 1 to 6, which was registered and numbered as title appeal number 48/2006. The learned first appellate court, after deciding the said appeal issue-wise, decided all the issues against the plaintiff and thereby allowed the appeal and dismissed the suit. It is under such circumstances that the present second appeal has been filed, and this court, by the order dated 12/5/2010, have formulated the admitted the appeal by formulating the substantial question of law. This court have also, during the course of the hearing, is of the opinion that an additional substantial question of law is required to be framed in the present facts. The learned counsel for both the parties were duly heard on that aspect, and accordingly, this court frames the following additional substantial question of law. Whether the learned trial court, whether the learned first appellate court was justified in dismissing the suit, even after taking into account, even though it was admitted in the pleadings by both the defendant numbers 1 to 6 as well as by the defendant number 96, that the land described in Schedule Go to the plain was transferred to the plaintiff number 1 by the deed of sale bearing deed number 3766/67 dated
2010 2019.
Huh?
2010 1967.
2010-19. Question. This court, upon hearing the learned counsel, is of the opinion that the first substantial question of law formulated is not a substantial question of law. The substantial question of law which was formulated by this court on 12/5/2010 is not a substantial question of law involving the instant appeal. Inasmuch as the learned first appellate court did not allow the appeal on the said aspect of the matter. Now coming to the additional substantial question of law as to whether the learned first appellate court was justified in dismissing the suit without taking into account the respective admission made in the pleadings by the contesting defendant numbers 1 to 6 and well as by the defendant number 96 in respect to the land described in Schedule 4 to the plaintiff. From this court have duly taken note of the pleadings on record, wherein it is a categorical admission on the part of the respondent on the part of the defendant numbers 1 to 6 as well as the defendant number 96 that the plaintiff number 1 was sold a plot of land measuring 2 bighas 2 lechas covered by dark number 5 covered by dark number 514, 515, 516, 526 of KP Patta number 71 of village Talimura under Niz Modortula by a registered deed of sale bearing deed number 3766/67 dated so and so. Under such circumstances, now this court further have also taken note of that the land which has been claimed by the defendant number 1 to 6 is the land covered by dark numbers 543 and 502, which are nowhere connected with the Schedule Go land. It is also relevant to take under such circumstances. This court finds no justification why the learned first appellate court dismissed the entire suit without taking into account the admissions made in the pleadings. Consequently, the issue therefore arises as to whether this court should remand the instant appeal back to the learned first appellate court, or should this court decide the said appeal. This court have duly taken note of that the pleadings are there, as well as the evidence are also there. Under such circumstances, as there is no requirement of any further evidence, the question of remanding the suit appeal back to the learned first appellate court would be only delaying the inevitable. Under such circumstances, this court takes up the matter for this court is of the opinion that the plaintiffs herein would be entitled to a judgment, would be entitled to the decree only in respect to the Schedule Go land. However, it is made clear that the plaintiff would have no claim over the Schedule Go land, which comprises of 2 plots of land, one covered by dark number 543 and the other covered by dark number 502. Accordingly, this court decrees the instant suit, thereby declaring the right, title, and interest of the plaintiff over the Schedule Go land. You are in possession? This court further grants confirmation of possession of the plaintiff over the scheduled goal and full stop. This court further declares that the plaintiffs have no right, title, and interest in respect to the scheduled call and full stop. Accordingly, the instant appeal stands disposed. The registry shall prepare a decree on the above mentioned direction and thereupon send the lower court records back to the court below.
Obliged.
In the present facts of the case, this court is not inclined to impose costs, and the parties herein shall bear the costs throughout the proceedings.
Obliged.
Obliged.
From that respondent number one.
Huh?
Respondent number one, he expired the first week of March.
When?
The first week of March 24. He is residing in Gujarat. Mr. E.J. Mahunto is appearing for the respondent, but his name is not reflected. Not reflected. Not respondent.
Appellants are alive,
Yes, sir.
so we dismiss the appeal. There is no problem.
Lordship, today it has got continuation of in court.
Mr. Counsel,
Your Lordship, our name has not shown you.
Mr. Counsel, I am saying if I dismiss the appeal, you have a problem. Take your seat.
No.
Yes.
By the
It's a court. It's a case of reverse dismissal, concurrent finding.
concurrent.
Then
Our main continuation letter,
what is the perversity?
exhibit 5 and 6, were not taken into consideration.
What is exhibit 5 and 6?
Lordship. Exhibit 5 is Jamapanti. The survey. But here the case of the plaintiff is that they purchased the land to auction sale in 1935. Their name is recorded. Sometime in the year 2008, they published a notice that they want to number one, defendant number one, published notice in that paper that his name should be recorded in the land register. Then the suit was filed with the plaintiff. Later, the plaintiff was a partnership form. It was dissolved in 1945.
Who is the plaintiff?
The plaintiff is the
Ramchandra Malpani
Ramchandra Pal.
versus
But Firod Kumar Borua and the third.
and Gobind Lal Malpani. Who is he?
But they were the co-patadar. They were the partners of that firm. They didn't contain the suit, so their name were deleted subsequently.
And who are the plaintiffs?
Plaintiffs are Lordship Ramchandra Malpani and Prakash Malpani. They were the partners of the earlier firm, putting the defendant number 2, 3,
You were the partners of
yes, firm.
what is that firm?
Lordship firm, his name is
Huh?
Mangiram Kishanlal.
Then?
That firm was dissolved in 1945.
How do you show it? What is your document to show that you have any relation with the firm?
No, Lordship,
You have not exhibited a single document.
Lordship,
Exhibit 1 and 2 is the photocopy of the Jamawandi not admitted.
no,
Did you call for the Jamawandi?
Lordship, subsequent, some other documents are there.
No. First of all, the basis is Exhibit 5 is a photocopy.
No, 5 and 6. 5 and 6. Exhibit
Huh?
5 and 6. Exhibit 5 and 6.
Is a photocopy.
No.
Oh, 5 and 5.1.
Yes.
And the mutation order.
Yes.
Notice in the corrigendum published in Dainik Janambhumi and so and so. Exhibit 5.1 admitted, Exhibit 6 admitted, Exhibit 7 admitted, Exhibit 8 and 9 revenue receipt. The revenue So what is wrong? Nothing is wrong. Rightly taken into consideration.
Exhibit 5. Exhibit 5.
5 and 6 have been duly considered.
If the court said that regarding option set, no proof has been found.
You did not submit anything.
Yes, but Lordship, the Bhavati says that, the Bhavati, exhibit 5, says the note says that was purchased on auction sale on that basis, it was executed, but I not the
Here it is written that Sitar uh, 25/8/35
25/8,
মতো
1936,
লং লং পুত্রে তালা 2 নম্বর
এক নম্বর স্থল 2 নম্বর
মাঙ্গিরামর নাম হয়। What is your basis to say this to be a endorsement as regards an auction sale?
this is the only proof.
Then nothing is there. You should have produced something to that effect that there was an auction sale. You must have got a certificate.
That is
You have not proved it. There's nothing wrong.
order of the
Judgment may be wrong at best, but that doesn't amount to yeah.
this is the only proof.
You didn't also bring on record the exhibit document to the effect that you have any connection with this Mangiram Kitchen.
Reading
Nothing is there. In fact, the court was more generous to take into account something from the records which are not even exhibited.
regarding farm and auction sale, getting
Okay. You have nothing to say. Hello, we dismiss it. I can dismiss
Okay,
it. I can't.
regarding his date is not but in month of
Huh?
month of March, first week of March, we expect.
Who?
Dependent upon the-
Forget about defendant. I can't pass an order against the defendant. Okay, but I can very well dismiss the case in favor of a dead soul.
Not that. I even but my duty is to inform.
Okay, not. The instant appeal under section 100 of the Code of Civil Procedure have been filed challenging the judgment and decree passed by the learned First Appellate Court dated 19/8/2009 in title appeal number 2/2009, whereby the judgment and decree dated 17/11/2008 in title suit number 2/2002 passed by the Court of the Civil Judge Jorhat was affirmed. This court, by an order dated 31/3/2010, admitted the instant appeal by formulating three substantial questions of law, which reads as hereinunder. Take a seat. For deciding as to whether the said substantial question of law arises are involved in the instant appeal, this court have taken up would like to deal in brief the facts which led to the filing of the instant appeal. From the record, it revealed that one Ramchandra Malpani and along with one Jay Prakash Malpani had instituted a suit being title suit number 2/2002 before the court of the civil judge senior division at Jorhat. The suit was essentially filed against the defendant, one Hiroj Chandra Borua. The remaining defendants, number 2, 3, and 4, were arrayed as performer defendants. From a perusal of the plain, it reveals that the plaintiff, along with the performer defendant number 2, 3, and 4, claimed to be members of an Hindu undivided family in the name and style of M.S. Mangani Ram Kishanlal. It was stated in the plain that M.S. Mangani Ram Kishanlal had purchased a plot of land in revenue auction sale measuring 1 biga 2 katha 1 lecha, covered by dark number 1652 old and 1653 old, corresponding to dark number 1887 new and 1888 new, of periodic patta 155 old oblique periodic patta 397 new, of number 1 Bamungao, Sarigao Moja, Jorhat. It was stated in the plain that their names were duly mutated by an order dated 15/8/1935. It was the further claim of the plaintiffs that the plaintiff continued to enjoy the right, title, and interest and possession over the said land, which was specifically described in Schedule A to the plain from the date of the purchase. However, they came across a public notice published in the Assamese daily, the inverted comma, Doinik Janambhumi, in its issue dated 29/6/2001, in relation to revenue miss case number 8/2000, pending before the court of the additional deputy commissioner bracket revenue Jorhat, claiming title in respect to the land as shown in Schedule A by the defendant. Full stop. It was the further case of the plaintiff that the defendant number one had no right, title, or interest over the said land described in Schedule A to the plain, but on account of his actions of trying to raise construction of the land and to block the right of user of the passage provided by the state PWD, the plaintiff have been compelled to approach the court by filing the suit seeking that declaration of their right, title, and interest and possession, along with the pro forma defendant numbers 2, 3, and 4 in respect to the land described in Schedule A to the plain, semicolon, a declaration that the right of user of the passage 10 feet in breadth originating from Sarigao / Nimati Road on the west and terminating to the Schedule A land on the east, semicolon, owned and managed by the state PWD. A decree declaring that the defendant number one has not acquired any manner of right to block the passage of 10 feet in the schedule breadth leading to the Schedule A land on the east to prevent the right of user of the passage of the plaintiff number 1 and 2 and the pro forma defendant number 2, 3, and 4 by raising the iron gate. For declaring that the defendant number 1 has illegally constructed the iron gate at the entry point of passage to obstruct the ingress and egress of the plaintiff number 1 and 2 and the pro forma defendant number 2, 3, and 4 into their land as described in Schedule A of the plain. Pursuant to the said suit being filed, the defendant number 1 filed a written statement. It was specifically denied in the written statement that the said plot of land described in Schedule A to the plain was purchased and was purchased by auction sale. It was further mentioned that the defendant was under exclusive and uninterrupted possession and the iron gate was already there. It was further mentioned that the plaintiffs and the pro forma defendant numbers 2, 3, and 4 did not have any legal right and possession over the suit land. And as such, the question of deprivation of any right as alleged that did not arise. On the basis of the said pleading, as many as 7 issues were framed, including the issue number 3, that is, whether MS Manganilal Kishanlal is a joint business of the plaintiff number 1 and 2 and the pro forma defendant number 2, 3, and 4. Semicolon. Issue number 4, that is, whether MS Manganilal Kishanlal purchased the suit land in described in Schedule A to the plain in the revenue auction sale and if so, whether the plaintiff and the performer defendant have acquired right, title, and interest and possession over the Schedule A land. The learned first trial court, by the judgment and decree dated 17/11/2008, dismissed the said suit. In doing so, the issue number 3 was decided against the plaintiff on the ground that the plaintiffs failed to prove the existence of MS Manganiram Kishanlal and had also failed to prove that they, along with the performer defendants, are purchasers of MS Manganiram Kishanlal. On the issue number 4, the learned trial court came to a categorical observation that there was no evidence produced by the plaintiffs to prove the fact that MS Manganilal Kishanlal purchased the suit land in the auction sale. And as such, the plaintiff never acquired right, title, and interest over the suit land. The remaining issues were thereupon decided on the basis of the primarily on the basis of the issues, primarily on the basis of the decision in issue number 3 and 4. The plaintiffs thereupon, being aggrieved, preferred an appeal before the court of the district judge at Jorhat, which was the learned district judge at Jorhat, by its judgment and decree dated 19/8/2009, dismissed the said appeal. In doing so, the learned being aggrieved, the present appeal has been filed. In the backdrop of the above, let this court therefore consider as to whether the 3 substantial questions of law, substantial questions of law so formulated, are involved in the instant appeal. The first 2 substantial questions of law are interlinked, inasmuch as the learned, inasmuch as they relate to as regards as to whether there has been any perversity in the decision of the first appellate court on the ground of non-consideration of Exhibit 5 and 6. This court have duly taken note of paragraph 11, 10 and 11 of the said judgment passed by the learned first appellate court. The learned first appellate court duly have taken note of Exhibit 5 and 6, 5 and 5.1, Exhibit 5 and 6. And on the basis thereof, had come to an opinion that the plaintiff have failed to prove that they had purchased the deed of sale, the Schedule A land by auction sale. No, it is well settled that the said decision passed by the learned first appellate court is an affirmation of the decision taken by the learned trial court on the facts of the case. This court under section 200 of the CPC cannot interfere with the findings of facts to arrive at, unless a perversity is being shown unless a perversity is shown by the appellant in the judgment passed by the learned first appellate court. It is a well-settled principle of law that a wrong finding of fact would not amount to a perversity unless such a finding of fact was based upon a misreading of the evidence or ignoring certain evidence which would otherwise have changed the course of the proceedings. In the instant case, from a perusal of the materials on record and more particularly a reading of paragraph number 10 and 11 of the judgment of the learned first appellate court, would show that the question of perversity does not arise. Under such circumstances, that the first and the second substantial question of law so formulated by this court by the order dated 31/3/2010 cannot be said to be a substantial question of law, to be substantial questions of law involved in the instant appeal. Next, coming to the third substantial question of law as to whether the learned first appellate court judgment was in compliance with the provisions of Order 41, Rule 31 of the Code of Civil Procedure. This court, having taken note of the judgment passed by the learned first for the appellate court, and also taking into account the requirements in terms with Order 41, Rule 31 of the court, is of the opinion that the learned first appellate court have duly taken note of the have passed the said judgment in compliance with the provisions of Order 41, Rule 31. Under such circumstances, the said cannot be therefore a substantial question of law involved in the instant appeal. Accordingly, the instant appeal stands dismissed with cost throughout to the respondents. With cost quantified at rupees 11,000, and the respondent shall be entitled, and the defendant shall be entitled to cost throughout in the proceedings. I have summed up everything in paragraph number 47. Let me read it. The writ petition challenging the impugned provisional attachment order dated so-and-so is maintainable. Being maintainable could not suffice. The court, while exercising the jurisdiction under Article 226 of the Constitution, is required to entertain the writ petition. The entertainability of the writ petition in a case where alternative remedies are available would depend on various factors as detailed by the Supreme Court in the case of Whirlpool Supra, as well as Godrej Sarali Limited. In the instant case, the questions raised relates to challenging the impugned order on the ground that it was wholly without jurisdiction as the preconditions for issuing the impugned order as stipulated in section 5.1 of the Act of Remand, as well as the second proviso to section 5.1 of the Act of AR were not fulfilled. The second question raised is a pure question of law as to whether a property derived or obtained prior to the enactment of the Act of 2002, or for that matter prior to the Act of 1988, being made a schedule offense, can be treated as proceeds of crime. The question raised being a question of law and question challenging the jurisdiction, in the opinion of this court, requires that the writ petition be entertained. The term proceeds of crime as defined in section 2(1)(u) of the Act of 2002 relates to property or properties derived or obtained directly or indirectly by any person as a result of criminal activity relating to a schedule offense, or the value of such property, or where such property is taken or held outside the country than the property equivalent in value held within the country or abroad. Therefore, the state definition of proceeds of crime encompasses three kinds of properties as detailed above in the instant judgment. The term proceeds of crime do not in any manner refer to the date the properties were derived or obtained. What it stipulates that any property or properties derived or obtained directly or indirectly as a result of criminal activity relating to or relatable to a schedule offense. Therefore, the emphasis is on the properties derived or obtained as a result of a criminal activity relating to or relatable to a schedule offense. The date of acquisition of the property being prior to the enactment of the Act of 2002 or the Act of 1988 being made a schedule offense with effect from 1/6/2009 has therefore no relevance. What is relevant is when the officer empowered under the Act of 2002 is taking up the matter, he has to form an opinion as to whether the properties were derived or obtained directly or indirectly as a result of a criminal activity relating to or relatable to a schedule offense. The contention of the petitioners that the property acquired by deed of sale dated 6/3/1997 could not have been brought within the fold of proceeds of crime is totally misconceived and fallacious. In order to exercise the power under section 5(1) of the Act of 2002, the twin conditions laid down has to be satisfied. That is, any person is in possession of any proceeds of crime, and such proceeds of crime are likely to be concealed, transferred, or dealt with in a manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime under Chapter 3. This satisfaction has to be arrived at on the basis of materials in possession, and the same has to be recorded in writing that the authorized officer has a belief of the existence of the twin conditions on the basis of the materials in his possession. As from the very definition of the proceeds of the crime, there are three categories of properties which can be proceeds of crime as detailed in the instant judgment above. It would be seen that from the said definition itself, the properties in the second category and the third category depend on the identification of the property of the first category. Therefore, without identification of the property of the first category, the authorized officer cannot apply the second and the third category. In the opinion of this court, in the instant case, the respondent number 2 recorded his reasons to believe without identifying which properties were proceeds of the crime, and merely on the difference between the known income and the value of the assets, had arrived at the opinion that the properties mentioned in the schedule to the impugned order are proceeds of crime. This was done on an incorrect interpretation of the term proceeds of crime, as could be seen from the law laid down herein, as well as the Supreme Court in Vijay Madanlal Chaudhary. For the purpose of taking action under the second proviso to section 5(1) of the Act of 2002, the authorized officer has to record his reasons that the offense of money laundering has been committed And if the proceeds of crime are not attached immediately, it would frustrate the proceedings under the Act of 2002. These reasons to believe have to be on the basis of the materials in possession of the authorized officer, and the same are required to be recorded in writing. In other words, the authorized officer has to come to an opinion on the basis of the materials in his possession as regards the existence of the three P's, that is, person, process, and product. However, nothing as such is discernible in the reasons so recorded. There is no mention why the impugned order is required to be passed with immediacy, or else the proceedings under the Act of Year shall be frustrated. There is no requirement for providing the reasons so recorded in writing to the person whose property is provisionally attached, as well as there is no requirement that such reasons have to be a part of the provisional attachment order for the reasons already discussed in the instant judgment. The impugned order so passed is contrary to the requirements of Section 5.1 of the Act of 2002, as well as the second proviso to Section 5.1 of the Act, for which the impugned order is set aside and quashed. The consequences of setting aside the impugned order is that the adjudication proceedings so initiated on the basis of the so-called notice dated 7/8/2020 by the adjudicating authority has also to be set aside and quashed, as the adjudicating authority gets the jurisdiction only on the basis of a valid provisional attachment order. The decision herein to set aside the impugned order as well as the proceedings before the adjudicating authority shall not act as a bar to exercise jurisdiction under Section 5 of the Act of Remand by the respondents by following the mandate of law, and more specifically the provisions of the Act of 2002. The interim order so passed on so-and-so in IAC number no longer survives in view of the above adjudication. Madam, these are the reasons which were given to me. I've given it back. And secondly, tell your people, you see, in this judgment I've recorded there are three types of properties which come under the proceeds of crime. Yes, 6397 having been acquired would come within the ambit of it, but you have to first identify that that is the proceeds of crime, and then only it is on the basis of that you are not going to get that property, then you can very well go into the question of value. Okay, just for example, he acquired this property in the year 1997. What you have done is from 1986 till 2012, whatever is his income, just for example, 1 crore, and he has got property worth 3 crores. So 2 crores is the difference. So whatever properties you have got of 2 crores, you have attached. That cannot be the thing. You have to identify, yes, maybe 1997, 86 to 1997, his income may have been 20 lakhs, but he has matched a property which is of 57 lakhs. So under such one, that would be a procedure. Can be. But you have to record those reasons.
I've got a respondent, my dear. Appellant side, I have not seen since morning.
Hmm?
Appellant side, I have not seen since morning.
Hello, let us dismiss it for default. None appears on behalf of the appellant on call, whereas Mr. M.A. Bhuria appears, Raj Bhuria appears on behalf of the appellant respondents. Appeal, in view of the appeal stands dismissed for for default. Interim orders, if any, stands vacated. The registry shall return the LCR to the court still. So as per them, it is 30 years.
My lord.
Huh?
No, for them, they're 5 years, 3 years. We have filed a my lord, suit initially. That was dismissed.
Your suit, it was your suit or your appeal?
Our suit.
Huh? No, no, no.
We have
It was
filed.
your appeal. Suit was dismissed.
Suit was dismissed, my lord, and appeal was allowed.
Thereby,
Thereby, my lord,
holding that it comes under 112.
yes.
Your suit.
The Union of India has filed a suit. My lord, here, actually, my lord, I am praying for some time, my lord, this matter.
Don't ask for time.
I have been engaged recently on it. The old matter. It has gone through the file.
None appears on behalf of the appellant on call. So Mr. A. Gupta appears on behalf of the appellant, respondent. So taking into account the above, the instant appeal stands dismissed for non-prosecution. The interim orders, if any, stands vacated. The lower court records be returned to the court.
Yes, your lordship. They have filed the IAs method. Also mentioned the morning method to call to record. But the concerned superintendent in WB was not available for your work. He was engaged in some other work. So it is delayed method in getting. I approached the other bench or other tables also, but they said it is scrutinized by himself. It should be passed by him. That's why it does not come record.
You are appearing for?
It's number 226,
Who died?
2 and 4.
You are paying for 2 to 6. The ID is 2 and 4.
Yes.
Who was the original plaintiff? Defendant? You are a plaintiff or defendant?
In this case, I think I was already engaged. I have newly engaged.
Can't be a 2007 matter, it cannot be. Yes, you are there. Original plaintiff was Abdul Razak.
Hello, we were the dependent. I'm the plaintiff too.
Original plaintiff was Abdul Razak. He died during the pendency of the suit. And as such, he was substituted. Now these substituted people died.
Yes.
Two.
Yes.
2 and 4.
Yes.
Sirajul Islam and Akoy Mia.
Yes.
But all others are already there. So the plaintiff estate is duly represented. Are you?
My lord, as they have died, my lord, and I was informed on the December. I filed within the time, my lord.
So what?
The
It's okay. We need not go into all these things. You argue your case.
The other courts, my lord, asked me to file.
Very well.
Specifically,
I will say that those applications are useless. Don't worry. You argue on your point as regards the jot rights.
my lord, today I am not prepared for hearing.
Yeah, no, we'll dismiss it for default. None appears.
Honestly speaking.
None appears. You have moved that appeal.
Yes.
This is a 2007
Come
appeal.
up for orders, my lord, and I have filed 3 IAs on the direction of the honorable courts, my lord. So I have not today prepared, my lord. It's up to your authority.
No substitution application has been received in respect of response number 2 and 4 by this section till date. 2 interlocutory application being filing numbers and so are in filing section in defective stage.
That
That
is
is
corrected, my lord, and that is also, my lord, perhaps now under process, my lord, and filed another for, my lord, setting aside of the automatic abatement, my lord.
You can't be not ready. Anyways, you are standing out there, that is enough for me to allow or dismiss. Yes. Suit was dismissed. Appeal was allowed. What is this job title business?
Lord.
What is this job title?
Use title.
Ah.
Under Zamindar, land of Zamindar, given to the it's called for the of their cultivating land. After few days, they give the arrangement in their name, not the under some method. Type of thing. Lord, maybe make this for a hearing method. I got prepared today. Big people come on order. My lord, and these IAs are there. That's why I was not prepared.
There's some of orders.
Yes, ma'am. For orders, sir, today.
Yes,
My
it's
lord,
for
and
order.
the IAs are. That's why I was unable that today hearing will not take place.
You are appearing for two.
Two seats.
Did you call for those IAs?
Yes, my lord, but it has not come, my lord, because I have approached there, my lord.
Mr. A.K. Talukdar appearing on behalf of the appellant submits that he had filed three interlocutory application being registered as,
My lord, this is not registered. I can give the filing serial.
I mean, filed three or two,
Three, ma'am.
three interlocutory application. When?
One in on 20 February and one yesterday. Two on the 20 February and one yesterday.
On 21/2/2024, as well as yesterday 27/3/2024. So let those list this matter again on 1st of April 2024, along with the said applications for consideration. Yes, it's a case actually of an SAO.
My lord, here my subject is, my lord, this second appeal has been, my lord, filed under wrong, my lord, provision of law.
Which one? The appeal.
Yes, the second.
It should have been under order for 41 rule 27, order 43 rule 1 you
3 to 1, 1 give.
read with 104.
So, my lord, my prayer is, my lord,
You are asking for setting aside that.
Yes.
Let's see why you want that. Let's see where is the order. Which is the order? Was there a stay?
judgment is that phase. It's 56. Page 11, the paragraph 11. It demanded the matter.
What I think. I leave. Yes, madam. Here, if you see the order sheet, after a long wait, on 1/11/2006, the Survey Commission's report was received. On 28/11/2000, and it was fixed for filing of objection. And on 28/11/2006, the report was accepted. Then the matter got transferred. Then matter was fixed for hearing, argument. On 6/3/2007, the hearing was concluded. Then both the sides present, and after perusing that, I find that further hearing is required on law point for further hearing. 3/4 due to paucity of that. 13/4 both sides to the learned heir pure without state. Then 17/5 a petition was filed by the plaintiff trying to reject the survey committee. And this report fixed it here, and the petition number 22 has not been pressed by the learned counsel. And as such, the judgment. So if it was not pressed, then the report having been already accepted, nothing remains. He could have gone. Are you in favor of the report or against the report? Yes, madam. You are in favor of the report or against the report? I hope you are in favor of it, because you don't want the matter to be remanded. Therefore, you are in favor of the report, because if it goes back, again it will be unnecessary.
Yes, yes.
You are the plaintiff.
We know. We are defendant. If in title suit, we are defendant.
Okay, the report must have come in your favor.
And this suit was dismissed on that is.
So you want the report to remain as it is. Chalo.
And thereafter,
We set aside this time and we remand the direct the trial court, the first appellate court to decide the appeal while setting aside this order.
Yes.
Because when the application was not pressed, the question of not hearing does not arise. And in fact, when the report had been already accepted, which was not taken into account by the first appellate court, isn't it?
and another thing I want to point out for lordship, my lord. Initially, we were not in the case before your lordship. The council conducting the case for the extract. Thereafter, the matter was dismissed on. It was dismissed, my lord. And after dismissal, we dismissed in 2015 on 29/5/15. Thereafter, we entered appearance. We appear, my lord, that appeal restored. Just for your pointing out this thing. Initially, we were not just subsequently.
Was the notice issued to them after dismissal?
A notice issued, my lord.
It was done.
And what happens? We are waiting for service to be completed, my lord. But,
You want to say only on the suspect that
yes.
you would not have, if you were the counsel, you would not have filed the RSC.
That is the amount I'm pointing out, my lord.
Right.
Because we did not examine that, my lord. We are waiting for service to be completed. Yes. I leave alone.
Okay. The instant appeal has been filed challenging the order dated, the judgment and order dated (35/2008), passed by the learned first appellate court, that is the court of the civil judge Jorhat, entitled appeal number 19/07, whereby the learned first appellate court remanded the suit back to the trial court for fresh decision after disposing of the objection filed by the appellant in the trial court. Full stop. In that, full stop. In view of the said order so passed, in view of the said judgment, no, full stop. In the opinion of the said of this court, the said judgment so passed is a judgment passed under Order 41 Rule, Madam, Rule 23A. Under Order 41 Rule 23A of the Code of Civil Procedure 1908. In that, accordingly, an appeal lies under Section 104 of the Code. Code of Civil Procedure 1908. And accordingly, an appeal actually lies under the provisions of Section 104, read with Order 43, Rule 1Q of the Code. Be that as it may, the appeal herein was wrongly filed as an appeal under Section 100 of the Code. And this court, by an order dated 25/7/2008, had admitted the appeal by formulating two substantial questions of law. Full stop. This court have duly taken note of that as the appeal herein is actually an appeal under Section 104 of the Code, read with Order 43, Rule 1R of the Code. Rule 104, read with of the Code. The question of going into the aspect as to whether any substantial question of law is involved in the instant appeal does not arise. Therefore, this court is required to only adjudicate in the instant appeal as to whether the learned First Appellate Court ought to have remanded the appeal suit back to the trial court, or should have decided the said appeal on merits. This court had duly perused the impugned judgment dated 3/5/2008 passed by the learned First Appellate Court entitled Appeal number 19/07. And from a perusal of the said judgment, it reveals that on the ground that the objections to the report of the survey commissioner were not heard by the learned were not heard by the learned trial court. The said appeal was disposed of by remanding the suit back to the trial court for deciding the suit afresh after deciding the objections so raised. Full stop. In order to do full stop, taking into account the same, the question therefore arises as to whether the learned First Appellate Court was justified in doing so. This court finds it very relevant to take note of certain important orders which were passed by the learned trial court prior to passing the order on 29/6/2007 in the suit being title suit number 10/1996. The record reveals that the suit have been pending for the report of the survey commissioner from 9/8/2004. Inasmuch as on the same date, the circle officer East Jorhat was appointed as the survey commissioner to conduct the survey and ascertain the actual spot of the suit land and submit a report. Almost no. 9/4 couldn't. After 2 years, the report was submitted on 1/11/2006 before the trial court by the survey commissioner. On that date, the learned trial court fixed the suit on 28/11/2006 for filing objection by the parties. However, on 28/11/2006, none of the parties submitted any objections, and the learned trial court, by the order dated 28/11/2006, duly observed that 2006 accepted the commissioner's report as part of the record. In view of the said order, the order dated 28/11/2006, the said report of the commissioner was duly accepted by the learned trial court, and consequently, in view of the provisions of Order 26, Rule 10, the said report becomes a part of the record. Thereupon, the record reveals that the suit proceeded and the hearing, the arguments proceeded, and the arguments were duly heard on 27/2/2007, 6/3 and 6/3/2007. The learned trial court thereupon fixed 23/2007 for judgment. However, on 23/2007, the learned trial court was of the opinion that further clarification was required on law point, for which the suit was fixed on 3/4/2007. The matter thereupon, on 3/4/2007, 17/4/2007, and 4/5/2007, the hearing was not completed. However, on 17/5/2007, the counsel for the plaintiff had submitted a petition for rejecting the survey commission's report and for reissue of a survey commission to fulfill the direction of the appellate court. The learned trial court, on such application being filed, fixed 21/6/2007 for filing objection, if any, by the defendants. On 21/6/2007, the defendants duly submitted their objections. However, on 29/6/2007, the application so filed by the plaintiff, being petition number 745/207, was not pressed by the learned counsel for the plaintiff, for which the learned trial court carried out the further hearing in the suit and reserved the said suit for judgment on 12/7/2007. Thereupon, on 12/7/2007, the judgment was delivered and the decree was prepared, against which an appeal was prepared before the learned first appellate court, which was registered as title appeal number 19/07. From the above records, it categorically reveals that the Survey Commission's report was duly accepted by the learned trial court, and there was no objection so filed on the date which was fixed by the learned trial court, that is on 28/11/2006. This court further finds it relevant to take note of the provision of Order 26, Rule 10, wherein it has 10(1) of the code, wherein it has been mentioned, wherein it has been stipulated the 10(2), wherein it has been stipulated that a report of the commissioner and the evidence taken by him shall be evidence in the suit and shall form a part of the record. Under such circumstances, in view of the statute itself, the report of the commissioner, which was submitted on 1/11/2006, had become a part of the record. This court also duly takes note of that the learned trial court had granted the opportunity to both the plaintiff and the respondent defendants to file their objections, which thereby fixing 28/11/2006, which the plaintiff or the defendant did not file any objections, for which the suit was fixed for arguments. It was only at the time when it was only at the stage when the learned trial court had fixed for certain clarification on certain law points, as could be seen from the order dated 23/2007, and that too after 3 dates thereafter. On 17/5/2007, an objection was filed. Which was bearing petition number 745/07. This objection, so filed in the form of a petition, was subsequently withdrawn by the counsel appearing on behalf of the plaintiff. Under such circumstances, the learned trial court did not commit any error in not deciding that petition number 745/07. Consequently, the order passed by the learned first appellate court for remanding the suit on the ground that the learned first trial court did not decide the petition number 745/07 is expressly erroneous and requires interference. Consequently, this court therefore sets aside the judgment dated 3/5/2008 passed by the learned court of the civil judge at Jorhat in title appeal number 19/07 and further directs the said appellate court, that is the court of the civil judge at Jorhat title, to decide the title appeal number 19/07 afresh 07 on merits. The records which have been called for by the registry of this court be transmitted to the court of the learned civil judge at Jorhat, so that the said appeal, being title appeal number 19/07, could be decided at the earliest after issuing the earliest. This court have also taken note of the fact that the suit was filed in the year 1996 and almost 28 years have passed by. And as such, this court requests the learned trial first appellate court, that is the court of the civil judge at Jorhat, to decide the title appeal number 19/07 by giving due urgency to the said proceedings after serving summons to the plaintiffs who are, however, not represented before this court. The defendant herein shall appear before the learned trial court. The defendant herein, the defendant who is the appellant herein, shall appear before the learned first appellate court, that is the court of the civil judge at Jorhat, on 2nd of May 2024, and produce a certified copy of the instant order. The registry, as directed herein above, shall transmit the records to the court of the civil judge at Jorhat on an urgent basis, so that the said court is in a position to take up the matter on 2nd of May 2024 along with the records.
Allowed to exhibit the
Only that. The instant application under Article 227 of the Constitution has been filed challenging the order dated 8/4/2019 passed in title suit number 154/2006, whereby the learned trial court, that is the court of the Munsif, number 1 at Dhubri, had permitted the plaintiff to file additional evidence, that too at a stage when the arguments were going on. Arguments were going on. From the materials on record, it reveals that during the course of, at the time when the arguments were going on, an application was filed under section 151 by the plaintiff, stating inter alia that the records of title suit number 400/81 and title appeal number 1/1993 was called for by the court and the same is tagged with title suit number 154/2006. Certain orders. He wanted to bring what?
You have to produce some records of TS 400/81, some missed case also,
Which are already there on record.
already there on record. Take with the record.
Certain, however, the records of the said the records of the cases which have been called for, the records of the title suit number 400/1981, title appeal number 01/1993, second appeal number 90/95, Mize case number 20/2000 and Mize case number 162/1981 have not been exhibited. Under such circumstances, the plaintiff sought for an opportunity by way of the said application that he may be permitted to exhibit those documents which have been more specifically described in the petition bearing petition number 3675 dated 24/1/2019. The defendant number 2D filed an objection to the said application on various grounds and reasons. However, the learned trial court, by the order dated 8/4/2019, permitted the said application and permitted this, allowed the said application filed by the plaintiff, thereby permitting the plaintiff to file additional evidence along with certified copies of the documents mentioned in the petition number 3675/19 by giving copies to the defendants. This order has been put to challenge. This court, upon hearing the learned counsel appearing on behalf of the petitioner, as well as the respondents, is of the opinion that no interference is required to the order dated 8/4/2019 passed by the learned trial court. However, this court also observed that taking into account the scope and ambit of the application which was filed, being petition number 3675/2019, the additional evidence to be submitted by the plaintiff shall be strictly limited to exhibiting the documents which have been mentioned in the said application and nothing more. It is observed and clarified that any further statement in addition to what have been stated above, mentioned in his evidence on affidavit, has to be disregarded. With the above, the instant petition stands disposed. This court further taking into account this court, in view of the above, the instant petition stands disposed. Before concluding, this court makes it clear that the order dated 15/11/2019, whereby further proceedings of title suit number 154/06 pending in the court of the Munsif number 1 at Dhubri was stayed, is hereby vacated, and the parties herein who are duly present before the court are directed to appear before the learned trial court on 6th of May 2024. On that day, the plaintiff shall file his evidence on affidavit only, exhibiting the above document only to the extent permitted herein above.
Okay.
Yes, Mr. Bishwa.
The divorce suit was filed in the court, family court by my friend. And I think the wife, my lord, it was sent for mediation, and almost more than 13 months it took the mediation.
Which order you are challenging?
My lord, I have been deprived of filing WS, my lord. That is the order date 21/6.
21?
21
Page, there is no page.
22. Page 22.
Huh?
Page 22.
Petitioner is absent with step, respondent is present, and the WS not filed. Hence, for PW, close WS. Oh, yes, why were you absent?
Because I was not absent, my lord. My matter was continually effort was made for mediation before the family court. Both the sides of, and that's why we are under the matter will be settled amicably. That's why we did not file the WS. But when it came, my lord, suddenly on that day I was not earlier date, my lord, I had no knowledge. But my advocate who was representing me did not file any WS.
Your WS is ready?
Yes, I can file everything.
Hello. Let them file.
I may just have a look at page 4 of it. Paragraph 5.
Mr. Counsel, your the petition was not dismissed on that ground. You are lucky. Petition is absent without steps. Then it should have been dismissed. You are lucky. Are you not lucky? Well,
I was
no,
absent with step.
husband, wife. Husband, wife.
Yes, yes.
There. Oh. This is an application. under section Article 2 to 7 of the Constitution, challenging the order dated 21/6/2023, whereby the learned court of the Principal Judge Family Court number 2, Kamrup Metro at Guwahati, had debarred the petitioner. The petitioner herein, who was the respondent in FC Civil Case number 1092/2021, from filing their written statement. This court had duly heard the learned counsels appearing on behalf of the petitioner, on behalf of the party. Mr. S.C. Biswas, the learned counsel, appearing on behalf of the petitioner, who was the respondent in the said proceeding, submitted that on account of a mediation proceeding going on, the respondent, the petitioner herein, was under a legitimate expectation that was under an expectation and hopeful that the dispute between the petitioner and the respondent herein would be solved amicably. However, on the date on which the matter was fixed on 21/6/2023, it was again the impression of the the petitioner herein, that there was a chance of an amicable settlement, for which the said written statement was not filed. The learned counsel submit that the written statement of the respondent or the petitioner herein is ready and can be filed on any day as may be fixed by this court. So this court have duly heard the learned counsel appearing on behalf of the respondent herein, who is the petitioner in the proceeding, being FC Civil Case number 1092 of 2021. So, after giving an due anxious consideration to the submission so made, this court, taking into account that the instant dispute pertains to a matrimonial dispute between the petitioner and the respondent, and the petitioner in view of the ongoing mediation proceeding was under a bona fide belief that the matter would be amicably resolved, did not file the written statement. This court is of the opinion that the same constitutes a sufficient cause. Under such circumstances, this court interferes with the order dated 21/6/2023, thereby permitting the petitioner herein, who is the respondent in FC Civil Case number so and so, to file her written statement on the next date as fixed by this court. On the next date of her appearance before the learned trial court. This is taking into account that both the parties are duly represented. The interim order passed on 28/7/2023 stands vacated, and the parties are directed to appear before the learned trial court on 6th of May 2024. On that day, the petitioner herein, who is the respondent in the said proceedings, shall file their written statement without faith. It is made clear that if the written statement is not filed on that date, the order dated 21/6/2023 shall revive.
The short point of this matter is this matter. One Monjid Ali, he purchased 3 bigha 8 katha land from one Rashid Ali. It is admitted fact. Monjid Ali has 3 sons and 2 daughters. One son died issueless, my lord. Then from the 2 sons, my lord, the defendants purchased their share 2 bigha 5 katha, my lord. From the 2 daughters, my lord, the plaintiff purchased from 2 separate sales.
You are the plaintiff?
I am the plaintiff. My lord, the 2 daughters, my lord, one is Moina Bibi and another is Lottu Bibi. Moina Bibi, my lord, here in the WS also, they have said, my lord, that they want only 2 bigha 5 katha, 2 bigha 5 katha, my lord, 5%. The rest they will relinquish. Now, in the evidence, my lord, what happened? I exhibited the 35 copy of the sale deed purchased by Monjid Ali, exhibit 2. 3 is the, my lord, the sale deed from Moina Bibi, and 4 is the sale deed from Lottu. Here, the purchase share of Lottu Begum was enclosed by him.
other side. We activated certified copy in the defendant in DW1 in the evidence my lord admitted that from the two daughters my lord they are the child is that mentioned my lord that they have purchased. They purchased 2 bigha my lord 5 katha only from the 2 sons surviving sons. And accordingly trial court dictated the 2 sons. For the 2 big my lord. So one share is to the plaintiff. The only Lakku share my lord was by. Now the appellate court dismissed the allowed the appeal on the ground that my lord the certified copy of the charges are not admissible. So yes, that is allowed that. This is the only fact of the case.
But whether those documents are marked, exhibited
Exhibited without objection. And the defendant admitted my lord those documents. If you will still see the evidence of DW1 in cross examination, I may it also my lord. He has admitted my lord. Just I am
Let us
just
see the trial of first appellate court judge.
yes. My lord, yes. My lord, it is at page 13. The party portion, my lord, let us see that it's not here. Well, 4, 5, 6, page 20. That's it.
Tell did which year?
Tell it, my lord, this is the one 11. That's the exhibit 4.
Which document is kindly come to paragraph 12?
In his evidence, PW1 during cross-examination stated that the document which the suit has been based upon is presented for registration before the register and the same has certain volume for which he could not get it. He again stated that it did not call for the original deed from the sub-register fees. From these statements of benefit, other established that the alleged deed is yet to be registered and lying before the register. This is wrong. Not registered. I have certified copy of the register. Tell it I have put. So
No.
this is the
EW1 stated that it is not registered.
hello?
EW1 submitted that he has submitted, but has it been registered?
Not volume. Not volume matter. Because earlier matter this cell is registered, thereafter matter is written in the volume matter. That's not volume dot. Not registered. It's not correct matter. This is wrong, man. And moreover, my lord, your lordship, just I am reading one sentence. Later on 20 purchase the land on 1/11/2006 from Lotsu Bibi, land 7 kata, 8 kata, 5 ganda, land in the Sud Pata and got its possession. Well, it's the evidence of this one. It's admitted by lordship, 1/11/2006. And here is WS also they have said, my lord, that they will relinquish if anything extra is there. Well, that also your lordship may just see that page, my lord. At page 55.
What do you say about compliance to Article Section 65?
Well, Section 65, my lord, here, my lord, when admitted document is here, when it is admitted, my lord, by the other side. So I think
Admission will happen later on.
Well,
Admission happen later on.
but, without the objection, my lord,
So without
the
objection, it can be adduced.
Well,
There's no requirement of compliance to 65,
some
65,
judgments,
63 and
some
65.
judgments are here and there, my lord, that if any without any objection, such an active state.
So here and there, let us have something here.
Well,
Then there I will find it.
if you have not right. This one, what I put my lord. Method is the Supreme Court para 621.
Yes, come to paragraph 9, the third page of that order. Devendra Chaudhary.
Okay.
I have considered the rival submissions made by the learned counsel for the parties.
Yes. Well,
Regarding the admissibility of the gift deed number 1 as discussed above, the defendant took all reasonable steps to prove the same as the original of AIO is stated to be lost. Admittedly, Exhibit 1 is a certified copy of so-and-so. Based on the decision so-and-so, I am in agreement with the ratio. Now, did you take that step?
well, I read it not for you, but
What you
but
didn't
in the written statement itself, my lord, they have admitted, my lord. Written statement also it is. So they wanted 2 bigger 5 customers. That's not disputed, sir.
Hmm?
That is not disputed, sir. If purchase share of 2 daughters, my lord, to have purchased, that is not. The evidence, my lord, I just just look at the evidence. So this is the evidence of this, matlab, this is one matter. That's right. And trial court consider this.
Let's see the trial court judgment.
That's what it says. The issue number, is 32, 425.
How is exhibit D, E, F have been exhibited?
EFM is expected by division.
How? Those have been disregarded. How? On the ground that they have photocopy. But they were not marked under objection. So can it now, if we allow your plaintiff to exhibit 4, 5, and 6, why not D, E, F?
Well, they have purchased two sons, my lord. Yeah. And in the
Please, sir.
WS also they have admitted that they have purchased the
Please,
shares of sons, my lord, up to 2 biga, 5 kata, my lord, 5 kata. And except that, my lord, if you also see paragraph D at page 11, 54, my lord, of that chapter.
Sir, see the plain, where is the plain?
Paint is, my lord, very short plate, my lord, at page 47. we have admitted that the defendants have purchased and their interest of two sons, Montirali Chaudhary, measuring 2 bigger 5 kata. We have admitted. And that is what they are demanding.
You purchased by two deeds. What are those deeds? Exhibit 4 and 5? 3 and 4. What is for exhibit 5? Because you purchased from the daughters of
Montirali.
Monzir
My lord.
7 kathas, 8 chatak, 5 gondas each. By two deeds. One is 966
Yes.
and the other is 1805.
And they purchased, my lord.
No,
one-
that is okay. But what is this exhibit 5 then?
Exhibit 5 is the land revenue challenge. Okay, that's part.
Land revenue column. Exhibit 4 and 5. Now, who is DW2 and 3? Now let us see the written statement. What do they say?
My lord, paragraph D, my lord, is very clear, my lord, that on admission, this should damage this. Paragraph
You
D.
have asked for one decree for declared recovery of
Only here, my lord, they mention about this one. So one died.
Now you said in your plane that he left 2 sons.
He left two sons.
He left 3 sons.
No, 3 sons, one died, is too late. Prior to that. That will be treated by DW1.
No, if he rise issueless,
Yes.
the further will be, it cannot be simpler. It is Mohammedan law.
Yes.
If it is a Mohammedan law, then could the daughters tell the entire thing like this?
No, the 2 sons, my lord, actually they admitted, my lord, in the, by the Delhi, they 29,995, they purchased land of 2 sons. There remain 2 sons, 2 daughters. Sir.
Hmm?
2 sons, 2 daughters.
No, maybe.
Hello?
Maybe.
Yes.
But could the daughter sell more than that?
No, they are not getting more. Half of the son, my lord.
No, they cannot get half of the son.
Yes.
Whether the third son
Yes.
who died
Yes.
predeceased his father.
My lord.
If it not,
Yes.
then it will be gone to the brother more.
But that is not the issue here, my lord.
That is the issue here. That is what has been
No.
categorically mentioned. Kindly see here,
Right.
paragraph number here.
Right.
F. The plaintiff stating that only 2 sons of Monzi Ali instead of 3 sons had made a hotspot of the calculation of Islamic share.
But paragraph D, it can also see, my lord. Paragraph D, my lord, they have clearly done, my lord.
They
Yes.
say that
Yes.
without admitting if the daughters of the Monzi Ali got less possession than their share,
Yes.
they ought to have litigated themselves. The plaintiff cannot do so.
Yes.
Are you saying that you have been deprived of the entire land? You have been dispossessed.
My lord, I am only regarding the two, my lord.
How much are you asking for recovery of possession?
My lord, it's one share, my lord, of the Lakshupiti, my lord. That's a 7 katha and odd, my lord. This is 7 katha, 8 katha, 5 katha. And my lord, what they are saying, my lord, in the paragraph B, they have said, if he is granted, defendants would be entitled to under D, my lord. They say that they are entitled to 2 bigha, 5 katha, 6 are getting possession of the same on that day, which is beyond the period limitation, would not claim any more land, and undertaking to relinquish if we are found to be possession of more land. That
You see, the total land,
is 3 bigha, 8 katha.
Huh?
3 bigha, 8 katha.
total land is 3 bighas,
8 katha.
8 kathas.
Out of which they are claiming only 2 bigha, 5 katha.
Okay. No, let us see. How many bighas is 1 katha? 22. 20. 20 kathas is 1 bigha.
20 kata makes 1 bigha, 16 chotak.
No, we'll come to Chotok later.
20.
Okay. So therefore, it is 68 kathas.
Yes.
My lord,
the father had 68 kathas.
my lord, if I, my lord, to interpret, it should be, my lord, actually, in our calculation, it should be 3 bigha 10 chotak, not 8 katha. 3 bigha 10 chotak of the land.
3 bighas, 10 shataks.
So, my lord, yes, 3 bigha equivalent to 60 katha. And 6 shatak is there.
And what is 10 shataks?
And my lord, the 16 chotak is equal to 1 cut.
No, it is only 10 shataks.
Only 10 chotak, less than 1 cut.
So that is 60 kathas and 10 shataks.
Yes.
Okay. Now, when did the father expire? Monzir Ali? 14, 15 years.
Yes, Lord.
And when did the next brother expire?
Lord, information.
Anyway, that is okay. No, therefore, no, because then can we take therefore, you have not mentioned in your written statement that.
Yes.
So under such circumstances, that aspect cannot be taken into account. Because your case is mostly on that. Now you say
yes,
that out of that, you are entitled to 2 bighas, 5 kathas, 6 shataks.
Lordship.
Which makes it 40, 45 kathas,
6 shatak.
6 shataks. What is the remaining?
15
4
katha.
shataks and 15 kathas.
Yes.
What is the petitioner asking for?
We are asking for 7 katha, my lord.
No. You have purchased twice.
Two.
You are asking for 7 kathas.
8 gonda, 8
chatak,
chotak,
5 gondas. So what is the double of that?
Double of that, my lord, I 14 katha around 6 chotak, something like.
So why you are disturbing him?
My lord, I am saying what my submission in this, my lord, because the land which they are claiming from purchase from one of the sister, it is not with 2 of the sister. She is claiming right title interest and my eviction from one portion of the land, my lord, which he has purchased from Lachu Bibi, my lord, one of the daughter of the one of my sister lordship. Now, question is this, my lord, in absence of any partition of the land, because they have sold the land without any partition. Therefore, I clearly admit, my lord, I said, if the court found that I am possessing something in excess of what I have purchased, so, my lord, they can take that position, I can relinquish. But what I respectfully submit, in this case, my lord, a commission was necessary, my lord, to ascertain. It will be helpful to all of them, my lord. Petitioner, plaintiff, as well as the respondent, my lord, to ascertain whether, in fact, my lord, I am in possessing the excess of land beyond what I have purchased for my purchase. So, this is my humble prayer, my lord. Let them ascertain, let the commissioner ascertain it. And if it is found, that is why I made a statement, my lord. Otherwise could have denied. My lord, that is my...
Mr. Let us make it simple.
My lord.
We are sitting in second.
I understood, my lord.
There is no application
my lord,
by the plaintiff or the appellant
my lord,
or the particular.
what I respectfully submit, my lord, there is the
power is very limited.
Power is with your lordship.
Power is
lordship.
When I sit out there in the read court, you say all this.
My lord, no, power is with your lordship, my lord.
No, simple question is,
lordship.
Total was 16 kathas, 10 shataks.
Yes, my lord.
As per you.
Yes, my lord.
If that be so, what is being, you claim only 45 kathas, 6 shataks.
Yes,
which makes it that there is remaining 15 kathas, 4 shataks.
15 kathas, 4 shataks.
If it is so, whether he is entitled to hear on the basis of that possession or not, are you saying that your possession or that, are you in occupation of more land or not? That is for the executing court to say. And the executing court thereupon, if he files an execution, you point out that this is the land where I am. Then matter ends out there that executing court can do under order section 47. Yes.
Only the one partition is required to be done in this case, my lord. Partition of the land. So that, my lord, land purchased by them can be identified, lordship. And I want
once this court gives a decree to the effect that he is entitled to these 7 kathas or 7 kathas, 8 chatak, whatever may be, twice, because he has purchased twice, then in that regard, whatever
My lord,
remaining is
whatever
there.
remains is that, my lord, suppose now the court has passed also a decree for the recovery of the possession. Whether I was occupying that portion of land or not, my lord, that has to be ascertained by the court first. That was not
Oh,
ascertained, my lord.
I am asking your client to do a particular thing there in the executing court. Say this very, make that very statement before the trial court, executing court. That look here, this is it. Because you did not raise anything else. Which land, or not. Because this court can the court direct when his prayer is not there for partition.
My lord, here I'm not taking so many words, my lord, but I have an issue of fame whether suit is mentally in the present form, my lord, whether without partition. My lord. Part issue number 2.
Now, isn't it the duty of the court when it is a suit for removal property,
My lord,
more particularly in view of the provision of Order 7, Rule 3,
my lord.
to have more properly the distinguished the boundaries out there? So the question is whether you are in occupation or not. That will be seen by the trial executing court. You can raise all these things. I can make a word out there. That is the only way out. I'll take your submission. I'll say that these are things which can be taken
I
care
got your
of in the execution in view of that judgment, Pratibha Singh or whatever.
Yes, yes.
I think that is the best. Because otherwise it is very difficult.
I understood because I have gone through the WS also, my lord. That should have been.
Because you have
more.
categorically admitted your limited AI is this.
Yes, my dispatch is if something is found beyond that.
You have no business.
Yes, yes. That I have seen the WS, my lord, because I can't develop my case also before in the second.
Now, what do you say about this certified copy being?
My lord, certified copy, my lord, yes, there should be a foundation, factual foundation of that. What are the reason, my lord? That also, and my lord, at least, my lord, the document by calling some person from
First of all, Mr. Ghosh, tell me whether a certified copy is admissible in evidence.
My lord, subject to certain conditions laid down by
that we'll consider later.
Yes,
would it be admissible in evidence at all, or the mode of proof is irregular?
My lord, there is to distinguish. There's a distinguishable. When document itself is admissible, it can be taken at any stage of the proceeding. My lord.
But
Are you saying mode of admission? My lord, in this case, should taken at the earliest opportunity.
No, not at all. On the date on which it is being.
Yes, my lord, exhibited.
Then is it the mode?
Then I have gone through judgment of the appeal. So what I respectfully submit, my lord, is subject to lordship consideration, correction for the basis, my lord. Whether, my lord, a commission under section 26 can be approached. So look into it. Sorry, lordship can pass in.
No, that is not. That is beyond this court jurisdiction.
My lord, order to at any stage of the proceeding, my lord.
Why should this court take that? You see, I'll record your submission and say that these things can very well be agitated before the trial. He has to go for it.
Yes,
you are not going to leave. Are you going to leave the land?
No. Because you have to get the fruit of the decree after all.
No. After the decree, normally it is supposed that you need not file an execution. Execution is only a follow-up to the effect that if the decree is not satisfied.
Yes.
But you are not going to leave the land unless he goes for execution. So then they take that point. And the court then will take the help of the revenue in view of that. That is the only way.
I live. So I can't declaration here.
Yes, this is the last item of the day. The instant appeal is directed against the judgment and decree dated 11/4/2011 passed by the learned court of the civil judge number 1 Kachar, Silchar in title appeal number 9 of 2010. Record hereinafter for short referred to as the first appellate court, whereby the judgment and decree dated 23/12/2009 passed by the learned Munsif number 2 Kachar, hereinafter referred to as the learned trial court, record close, in title suit number 20 of 2008 was reversed. Thereby, it is this court, pursuant to filing of the instant appeal, admitted the appeal by formulating three substantial questions of law by an order dated 19/5/2014, which are reproduced hereunder. In order to ascertain as to whether the three substantial questions of law so formulated by the order dated 19/5/2014 are involved in the instant appeal, so let this court briefly take note of the facts leading to the filing of the instant appeal. Problem arises, Mr. Saiwala, in reading the judgments. The judgments make the facts more complicated. The plaint is much simpler. The pleadings are much simpler. I don't understand why the people they make it so complicated.
My lord.
Particularly trial court
On
judge.
admission, my lord, that could have been done.
Not only that, you see, they have made it very
Very
complicated.
complicated. Very good.
The fact, if you read the plaint, I think that is enough. From a perusal of the materials on record, more particularly the copy of the plaint, it revealed that the second RS Patta number 100 was issued with dark number 266 with an area of 5 bighas, 11 kathas, 5 chataks. The said patta was issued in the name of 3 persons, including one Rasid Ali Loskar. It is relevant to take note of that the second RS patta number 100 was curved out from RS patta number 75. And the said Rasid Ali Sarkar during the RS period purchased 3 bighas, 8 kathas of land from the recorded co-sharer, and he got possession of the land. Subsequent thereto, his name was duly mutated in the RS period. During the lifetime of the Said Rasid Ali Laskar, he sold the 3 bighas 8 kathas of the land to one Monozir Ali Chaudhary, since deceased, and delivered possession. The name of Sri Monozir or Monozir, JIR, Ali Chaudhary was duly recorded, duly mutated in the Jamabandi of the Sutpatta. The said Monozir Ali Chaudhary expired. It is the case of the plaintiff that the said Monozir Ali Chaudhary left behind 2 sons and 2 daughters, whereas it is the case of the defendant that late Monozir Ali Chaudhary left behind 3 sons and 2 daughters. However, in the written statement of the defendant, nothing is seen as to whether the 3rd son predeceased his father. Be that as it may, in terms with the Hanafi, they are Hanafi? Hanafi?
Yes.
In terms with the Hanafi law of inheritance, the sons of the late Monozir Ali Chaudhary, namely Rahim Uddin Chaudhary and Siraj Uddin Chaudhary, got 2/6 share each. That is 1 bigha 2 katha 10 chataks 12 gandas each, and the daughters received 1/6 share each. That is 11 kathas 5 chataks 6 gandas. The land which was inherited by the sons of late Monozir Ali Chaudhary was purchased by the defendants, whereas the plaintiff, by registered deed number 966 of 2006, dated 2/6/2006, purchased 7 kathas, 8 chataks, 5 gandas from one daughter of late Monozir Ali Chaudhary, that is one Moina Bibi. In addition to that, the plaintiff purchased another plot of land measuring 7 kathas, 8 chataks, 5 gandas by the registered deed of sale bearing deed number 1805 of 2006 on 1/11/2006 from the other daughter, that is one Lachu Begum. Both the lands which were purchased by the plaintiff were contiguous lands, and the plaintiff, after getting physical possession, started growing paddy to his men. It was the further case of the plaintiff that in the last part of April 2007, the defendant dispossessed the plaintiff from the land which the plaintiff purchased from Lachu Begum. And the same was specifically described in the schedule to the plaintiff. It is under such circumstances the suit was filed, seeking declaration of right, title, and interest in respect to the land described in the schedule to the plaintiff, for recovery of past possession by removing the defendants, their men, agents, by demolishing any obstacles or hindrances, if any, from the schedule to the plaintiff, for permanent injunction restraining the defendants from alienating the suit land, and from changing the nature and character of the suit land, etc. The said suit was registered and numbered as title suit number 20/2008. The defendants jointly filed a written statement. In the written statement, various pleas were taken as regards the preliminary objection. Various preliminary objections were taken as regards the maintainability of the suit. It was further mentioned that Monzir Ali Chaudhary had 3 sons and 2 daughters. It was mentioned that the 3 sons of Monzir sold out their 3 shares inherited to the defendant by registered document bearing deed number 2, registered document dated 29/1995 for a valuable consideration of rupees 40,000 for more or less 2 bighas, 5 katha, 8 chataks. The defendants further claim that their entitlement was only limited to 2 bighas, 5 katha, 6 chataks, and nothing more. It was mentioned that the defendant did not mention as to whether the 3rd son of the predeceased Monzir Ali Chaudhary. The 3 sons. It was also mentioned that the plaintiff had made a hodgepodge with the calculation of the entitlement of the daughters without taking into consideration the share of the 3rd son. In addition to that, it was also mentioned that without the impleading the co-sharers to the suit, of the patta to the suit, the suit was not maintainable. On the basis of the above pleadings, as many as 7 issues were framed. The issue number 3 related to whether the suit was barred by limitation. The issue number 4 related to as to whether the plaintiff had right, title, and interest over the suit land. And the issue number 5 and 6 related to as to whether the plaintiff was entitled to recovery of khas possession as prayed for, and also as to whether the plaintiff is entitled to a decree of permanent injunction as prayed for. In the said suit, the plaintiff adduced 3 witnesses and exhibited 4 documents. And exhibited 5 documents. Exhibit number 1 is the certified copy of the Jamabandi of the second RS Patta number 100. Exhibit number 2 and 3 are certified copies of the deeds of sale. 2, 3, and 4 are certified copies of the deeds of sale dated 18/5/1954, 2/6/2006, and 1/11/2006. Whereas exhibit number 5 is the land revenue paying challan of 1414 BS. It is relevant to take note of that these documents were exhibited without any objection. On the other hand, the defendant, number 1, the defendants only exhibited the evidence of DW1 witness. Further to that, the defendant exhibited various documents as exhibit A to exhibit H. It is relevant to take note of that exhibit H is the original deed number 1595/1587 dated 2995, by which you have purchased.
Yes, yes.
By which the defendants purchased the deed of their land. The learned trial court, on the basis of the said evidence, decreed the suit in favor of the plaintiff, thereby granting the reliefs which were sought for. By the judgment and decree dated 23/12/2009. Being aggrieved, an appeal was prepared by the defendants before the court of the civil judge number 1 Kachar Guwahati, before the court of the civil judge number 1 Kachar Silchar, which was registered and numbered as title appeal number 9/2010. The said appeal, however, was allowed by judgment and decree dated 11/4/2011. In doing so, the suit of the plaintiff was dismissed on the ground that the plaintiff only adduced the certified copy of exhibit 2, 3, and 4. Exhibit 4 and 5, 3 and 4. And that too, not in compliance with, not without complying with, and that too, without complying with the mandate of Section 65 of the Indian Evidence Act 1872. Being agreed, the instant appeal has been framed, and this court, by order dated so and so 19/5/2014, have admitted the appeal by formulating the substantial questions of law as already reproduced herein above. This court have also heard Mr. G. N. Sahewala, the learned senior counsel, appearing on behalf of the plaintiff oblique the appellant, submitted that it was an admitted fact that the defendant, by the defendants during their cross-examination, that the plaintiff had purchased the 2 plots of land from the daughters of late Manzoor Ali Chaudhary. He further submitted that from the very written statement, the claim of the defendants was limited to two bighas, 5 kathas, 6 chataks.
5 kata, 6 kata.
And the remaining land thereafter was 15 kathas, 4 chataks. And as such, the plaintiff, the vendor of the plaintiff, the vendors of the plaintiff were duly authorized as per the share to get the said land, to transfer or convey the said land to the plaintiff. He submitted that the learned first appellate court, he submitted that although there are 3 substantial questions of law, but the 3 substantial questions of law are interlinked and can be subsumed as to whether the learned first appellate court was justified in dismissing, allowing the appeal by rejecting, was justified in rejecting exhibit 3 and 4. That too when the said documents were duly admitted into evidence without objection, and the defendants duly admitted the said purchase in their cross-examination. The learned counsel further referred to the judgment of the Supreme Court in the case of R.V. Venkatachala Gonda versus Arulmigu Vestwari Swami and B.P. Temple and another, reported in 2003 8 SCC 752, and drew the attention of this court to paragraph number 19 and 20. On the other hand, Mr. S.K. Ghosh, the learned counsel appearing on behalf of the respondent, submitted.
Hello, BJ.
BJ. Mr. B.J. Ghosh, the learned counsel appearing on behalf of the respondent, submitted that the fact that the said documents were duly, the said exhibited documents, being exhibit 3 and 4, were duly admitted, duly exhibited without objection, is not in dispute. He, however, submitted that the plaintiff, having not filed the suit for partition, which he ought to have done, the suit itself was not maintainable, inasmuch as without ascertaining which plot of land actually belongs to the plaintiff and which plot of land belongs to the defendants on the basis of the deed of sale, which was executed in favor of the defendant, Exhibit H, the decree for recovery of khas possession cannot be given due effect. He further submitted that a perusal of Exhibit H would clearly show that the said document was executed in the year 1995, much prior to the plaintiff coming into having claimed any right or title over the shares which fell in favor of the daughters of late Manjur Ali. I have given the due consideration to the respective submissions made by the learned counsels appearing on behalf of the parties. This court has duly perused the judgment passed by the learned First Appellate Court, and from a perusal thereof, it reveals that the learned First Appellate Court allowed the appeal and dismissed the suit primarily on the ground that the certified copies of the deeds of the registered deeds of sale, which were exhibited number 3 and 4, could not have been taken into consideration by the learned trial court without due compliance to the provisions of Section 65 of the Indian Evidence Act 1872. Good stop. Under such circumstances, the question arises as to whether the learned First Appellate Court was justified in doing so in the present facts. No doubt, it is the mandate of the law that the primary evidence is required to be adduced as evidence. It is not in dispute that a certified copy of a deed of sale can be exhibited, is admissible in law, provided the said document, provided the formalities which are required in terms with section 63 and 65 of the Indian Evidence Act are duly complied with. The above aspect makes it clear that a document, above aspect makes it clear that exhibiting the said documents, exhibiting the certified copy, above aspect of the matter therefore makes it clear that the said documents having been exhibited and having been admitted into evidence and exhibited and marked as exhibit amounts to the mode of proof being irregular or insufficient. It is well settled by the judgment of the Supreme Court in the case of R.V. Venkatachala Gonda Supra that a document which is otherwise admissible but on the ground of exhibiting the same in an irregular or insufficient manner can be duly regarded as evidence if objections were not taken at the time of tendering the said document into evidence. In the instant case, it would be seen that Exhibit 3 and Exhibit 4, the Exhibit 1 to 5, all were admitted into evidence without any objection. Under such circumstances, this court also finds it relevant to take note of that the learned trial court have also dealt with the said aspect of the matter and observed that the said exhibited documents could be read into evidence. However, the learned first appellate court observed that the said document, more particularly Exhibit 3 and 4, having not been adduced by following having been adduced not in the proper mode of proof, cannot be adduced, could not have been taken into consideration by the learned, could not have been taken into consideration by the learned trial. In the opinion of this court, the said Exhibit 3 and 4 having already been admitted into evidence without any objection, and more so when the said document was otherwise admissible. In the opinion of this court, the learned first appellate court erred in law in doing so. This court also finds it very pertinent to observe that there is no dispute by the defendants in their evidence on their cross-examination during the course of the trial did not dispute the said two deeds of sale. Even in the pleadings, there was no dispute as regards the said two deeds of sale being Exhibit 3 and 4. Under such circumstances, this court is of the opinion that the substantial question of law so framed duly arises in the instant appeal, and accordingly, the impugned judgment and decree stands set aside and quashed, and the judgment and decree passed by the learned first trial court is restored. Before concluding, this court duly takes note of the submission of Mr. B.J. Ghosh, the learned counsel appearing on behalf of the respondent, as regards that the suit was not maintainable as it has not, as the plaintiff did not file a suit for partition. This court is of the opinion that the said submission cannot be regarded at this stage, more so when the suit otherwise was maintainable in terms with Section 34, read with the proviso to the said section, is otherwise maintainable in terms with the proviso to Section 34 of the Specific Relief Act 1963. Be it as it may, in view of the judgment of the Supreme Court in the case of reported into the defendants herein the defendants herein shall be at liberty to raise such objections as regards the identity of the land during the course of execution.
Three boundaries.
Huh?
Three boundaries are there.
You have purchased a sale deed. He has also purchased a sale deed.
Boundaries are there.
But none of the courts have decided that. Na?
Yes. Correct.
Your sale deed is, and the plain sale deed is exactly the same. And how did they exactly identify that 7 kathas, 8 gondas of land which have been sold to you? Not a point more, not a point less.
The boundary is in both.
There will be the artification, my lord.
And there
Executing
it is also boundaries there.
Because my case is like I said, my lord, if I occupy something more, and if I encroach upon their land, my lord,
They will relinquish.
then I said, therefore, identification is required, my lord. I said, I have not occupied any land beyond the land which I purchased through Exhibit H, my lord. That I categorically admitted.
There is a boundary in
So,
there.
therefore, my lord, what I said, therefore, commission was necessary that I submitted before your lordship to identify whether I have in fact actually encroached upon their purchased land, my lord. So that they are entitled to get a recovery of the first position by evicting me. It's my humble submission.
Before concluding, the colonna is otherwise maintainable in view of the proviso to Section 34 of the Specific Relief Act. This court further is of the opinion that not only the trial court, in terms with Order 7, Rule 3, read with Order 20, Rule 6, Rule 12, Order 20, Rule 12 of the court, but also the executing court is empowered under Section 47 to decide on the identity of the land, and as such submission cannot be taken into account in the present proceeding. This is the only way I can give you. Nothing more. What? Please.
I've prayed for item of 5 years. After there is some emergency, Mr. May kindly be taken on preferential basis.
What happened? What is the emergency?
Emergency of doctor, actually,
You say about an emergency at 5 o'clock.
no, actually during this month it was listed, but because of shortage of time, it was not reached here. I'm just
Which year?
2014.
14, what is the urgency?
And your lordship, actually this land is under occupation, my client's occupation. Lordship.
Item number 5.
Yes, sir.
Chalo, we'll have it when? When do you want it?
This
I
week-
don't know. Next week am I sitting or not?
Yes, your lordship, your lordship.
I'm sitting?
Yes, your lordship, the dentist said that.
Has changed?
Yes, sir, I don't know, the dentist said that. Just a few minutes back.
When is same? Let's see. I don't know.
Your lordship, actually the matter is not related directly that some drug addict people are disturbing the possession, and police used to come now and then, and they are threatening our caretaker to kill them because they have the 2 marriageable daughters, and that drug addict that they are teaching that for that caretaker under compulsion, he has shifted his daughter to the other place. And my position is disturbing about it. Police also say to my client over phone that you do something, otherwise it will be a case of murder.
Hello, we'll take it up on. Am I sitting?
As they say,
Very difficult. Na? Okay, let's take it up on the 2nd.
yes, sir.
5 to on 2nd.
I could not 26 that there is injury motor.